All right. Sorry for the delay. I don't know who's in here, if anybody. I don't see many people. This is the middle of the day, but I wanted to jump on here and try to share the stream. Um, they are at the Statehouse today. Excuse me. There's a bill that's trying to be passed, and Jen Root is kind of spearheading this whole thing. And this is for this is a hearing today for the Medical Civil Rights Act. So it basically guarantees that officers will, people that in medical emergencies will actually, you know, take these people into consideration and actually try to save them instead of unaliving them like they have been. You look at Just on Root's case. You look at um, recently Francis Gigliotti and Haverhill. Again, these people are having mental health issues, they're having crisis, and they're calling out for help, and then they're being basically suffocated, and it's a horrible thing. So today we have um, Ken Root, I believe, is going to be speaking at this hearing, and Peter Murphy is also going to be speaking. I know there's a number of other speakers, and this is a scheduled for a pretty long hearing, and I know there are a lot of um, different things on this hearing today to go through. So I'm not sure exactly when in line this part of the hearing will be. So we may be waiting for a little bit, but I'm going to let this run, and we'll see what happens. I'm hoping it starts up here pretty soon because I'm actually on my lunch break and I'm on borrowed time. So I don't know who's here. I don't see really anybody here, but that's all right. Whoever the other one person is, good to see you. Say hello in the chat if you can, if you want to. Um, so yeah, we're just waiting. This thing should be starting up any minute. Typical to the State House, it's supposed to start at 1 o'clock, and anything to do with hearings and any kind of legal issues or concerns, it's hurry up and wait. So here it is, 1:04, and we're still waiting. But this bill it's important. I mean, people are getting. Naomi, how are you? Good to see you. Thanks for jumping on. Um, just saying. So Tracy was just live actually outside the State House, and there's a good handful of people that were there with her. Like I said, Peter Murphy was there. He's speaking today at this. Jen Root is there, obviously, and she's speaking as well. I know Timma and Brandy and St. Ross. It was a good little crew there. So, Jen made a statement out in front of the State House. She had a speaker, and it was, obviously that's a great location. There's a lot of people down there. So, hopefully, this movement gets a little bit of traction. It's definitely important, and families like Jen's family, and Francis Gigliotti and Haverhill, his family, they get their family members that were, these men were killed and not treated properly, and the medical emergencies that they were undergoing at the time were basically overlooked, and you understand where there's a lot of adrenaline that goes on during these things. I mean, I'm not a police officer. I have no idea what it entails, that type of thing. Nobody wants to live in fear because you're in that job, and people are acting out. You kind of, it's like a fight or flight instinct, I guess that takes over for a bit, and you get caught up in the moment. I get it to a point, but there's a lot of people there with the Gigliotti thing. There was a lot of officers around, and it could have just taken one of them to say, "Hey, hold up, let's back up, let's reassess the situation." And I think it should be the case in every situation. There should be someone in charge, someone that has a little voice of reason instead of being caught up in the moment or letting their buddy, do what they want to do and manhandle and, I don't know, treat people this poorly. So, hey, Dennis, what's up, bud? How you doing? So, yeah, so the crew's in there, Timmer and Brandy, St. Ross, Tracy, Peter Murphy, Jen Root. I believe I saw Nancy there, and I'm not sure who else was there. It was a few other people. Tracy was live out there for about 35, 40 minutes, and I believe they all just went inside. So we'll see what happens here. I'm hoping this. Hey, Abby Noni, how are you? Good to see you today. Um, yeah, we're just waiting for this thing to start up. I'm hoping this is an actual stream that comes through because typical to anything else like a Zoom call or anything like that. Um, Anything is possible with failures, system failures, and that type of thing. So there was a stream on that was from earlier, from 10 o'clock this morning, and I was able to play it live. So I'm thinking that this one should pop up. So hopefully it'll start up here quick. Let me refresh this page. Hold on a second. All right, let's see what the hell's going on here. Bear with me for a minute. Oh, wonderful. Good timing. So I just got a meeting request invite for work on my lunch break. So that worked out pretty good. All right, let me see. This thing's not, I don't know why it hasn't started up yet. Come on with it, Statehouse. Let's get your shit together. I think that morning hearing is over because it's not on there anymore. So this thing should be starting up pretty quick. Yeah, that's their default. Yeah, let's test it with this.
Meeting on state administration's hearing to review matters concerning state regulations, land bills, and owner designations will come to order. I want to welcome everybody.
Can you hear that? Does anybody confirm that that has audio? Because once the actual hearing starts, I want to make sure we can hear it and not have a problem with it. So,
Vice Chair Jamie Eldridge, Senator Jamie Eldridge, Senator Sal DiDomenico, Senator Becca Rouse, Senator John Beals, and Ranking Minority Member Senator Peter Duran. My colleague and co-chair, Representative Cabral, will be joining us shortly.
yeah, it looks like it's working. So,
and also like to recognize members.
All right, let me go back to the other one.
House Vice Chair Chad Tyler, Representative Estela Reyes.
Yeah, so a lot of hearings in this place. Okay. Thank you, Abby Noni. I appreciate it. Yeah, so we're gonna just wait and kind of wait it out. I really didn't plan to go live. I am working today. I'm working from home, but Tracy was in there with that crew, and they were, in there to support this bill. And I wanted to see if I could capture this while I was here. So, it really truly is. It's an important thing. I mean, you know, people are being treated poorly because they have mental issues or mental health issues going on at the time. And it doesn't seem like it's considered. A lot of people just look at it like, these people are lunatics, or um, they shouldn't be acting like this. This is wrong. So we should, basically, in a sense, assault them and treat them poorly. And next thing you know, these people are, getting killed, and it's awful. Again, we should totally be um, encouraging the officers to do the right thing. And like I said, it's not a matter of me knowing what the hell what to do in those situations. I'm not in that situation. Adrenaline gets the best of everyone, and I understand that. But it's like when you're in a fight with someone and you're beating this person in a fight, and to the point where this person can't defend themselves anymore. You would assume that someone's going to jump in and shut it down. Like, all right, that guy's had enough. That's enough. And it seems like that's not the case. And the difference between wanting to live and wanting to breathe, and potentially resisting arrest, or whatever you want to call it. It's a fine line, I suppose. But nobody deserves this. Nobody deserves to be trying to be detained and being killed in the process. So I don't know. We'll see what the heck happens here. But I know Peter Murphy has quite the speech prepared. I know Jen Root obviously is going to have plenty to say. There is someone that is on board, someone that's sponsoring this bill or this act. I'm not sure it's actually a bill. His name is. God's sakes. Hold on a second. His name is Christopher Hendricks. So Christopher Hendricks is I don't know who the hell this guy is, to be honest with you. Let's see if we can figure out who Christopher.
All right, welcome everyone to the Judiciary Committee hearing. Today is September 9, 2025. My name is Michael Day. I am the House Chair of the Judiciary Committee. With me is my friend and colleague and co-chair, Senator Lydia Edwards. And, welcome, Senator Edwards, and ask her to introduce the members of the Senate who have joined us.
Thank you very much. Again, Senator Edwards, Senate Chair of the Judiciary Committee, and I believe with us is Senator Pat O'Connor, who's a member of the committee, and other committee members may join us. I don't think anyone's online right now. No senators are online. Okay, all right. I'll introduce them when they come.
Perfect. Thank you. With me today, starting from the far left, is Representative Higgins. To her right is Representative Kilcoyne. To her right is Deputy Counsel Robert D'Alessandro. Down the far right beside Senator O'Connor is Ranking Member Representative Berthium. And to his right is Representative Sullivan Almeida with George Michael. Congratulations, Representative Sullivan Almeida. Before we begin, I want to run through some ground rules that we have at the Judiciary Committee for those of you who've never testified here before. We've got about 75 folks that have signed up to testify today. So to ensure that everyone who's registered to speak, we limit testimony to 3 minutes per individual. Panels of 2 will have 5, and panels of 3 will have 7 minutes per panel. Individuals may speak once per hearing, but may address more than one bill during their allotted time. I'll do my best to prioritize those who are here to testify in person, and then make sure we cover those who are here virtually as well. We've got 55 legislative proposals noticed for today. Summaries of all those bills are located on malegislature.gov. The committee must report on House bills considered during this hearing by November 8, 2025, subject to House Rule 27. As I mentioned, we've got about 75 individuals, both virtually and here in person, signed up to testify. I ask you to take that into consideration when you are called up. We want to be considerate so that every person has a chance to testify and share their stories with us. We ask anyone watching or waiting to testify, please be respectful and refrain from any disruptive use of cell phones. And I see a few members out there with pagers. Please mute those as well. We also reserve the right to remove anyone from the hearing room who is causing disruption. Some of this may be emotional testimony. We are not going to have anyone intimidated when they come up. So to that end, there'll be no signs or displays allowed when you come up to testify. No person may read the testimony of another individual, but the committee will accept written testimony at any time for as long as this bill is being considered by the committee. You may submit written testimony by mail to the Joint Committee on the Judiciary at 24 Beacon Street, room 136, Boston, Mass. 02133, or for House bills by email to Talia Quinn at talia.quinn@mahouse.gov, or for Senate bills to Eduardo Moreno Mendez at morenomendez@masenate.gov, and a CC to Christiana Golden at christianagolden.golden@masenate.gov. All written testimony will be made publicly available, provided, however, we, the chairs, may limit or redact testimony that is obscene, includes sensitive personal information, or information in our judgment that may jeopardize the health, wellness, or safety of the testifier or others. To that end, if you are recording today on your own device, it's simulcast on the legislative website, please alert Talia Quinn. There may be testimony that is of a highly sensitive nature that we will not be recording. So again, please alert Talia Quinn if you've not yet done so. Talia is down running the computers on my left. We'll be calling testifiers based on the bill number you signed up for on the registration form. If you signed up for multiple bills, you'll be called based on the first bill you listed on the registration form itself. I also want to welcome and recognize Representative Cataldo, who has joined us, a member of the committee as well. We'll begin today with testimony on H 1811, an act requiring clean slate automated record sealing, and welcome up Representative Keith. Welcome.
Thank you, Chair Day, Chair Edwards, and members. I appreciate being taken today so quickly. And Representative Vega was going to be, Vargas was going to be give testimony today, and he had a family situation that didn't allow him to come. And I just want to be pretty brief today and to the point, because I know you've already, as a committee, heard the Senate version of this bill, and I'm going to be speaking pretty much to the same testimony that you've heard before. So without further ado, H1811, an act requiring clean slate automated record sealing for Massachusetts. Tens of millions of people across the country, many of whom were never convicted, are saddled with court records that block access to employment, housing, and education, and make it almost impossible to start a business or fully engage in civic and social community life. Here in Massachusetts, we have over 1 million people that are affected in this way. That's 1 out of 5 persons here in Massachusetts. What we're looking for is a way to sort of eliminate the obstacles that can get in the way for people that have really carried on with their lives beyond the 3 years waiting period for a misdemeanor or a 7-year waiting period for a felony. And as I said, it affects all aspects. When I speak to groups about this bill, I usually start by asking, has anybody in the audience ever made a mistake that you really hate to think about and look back on? And I really think that's the case. And everybody raises their hand, right? But when this happens to you and you've made a poor choice in your lifetime that is difficult to think about, it's exactly this reason that we need clean slate to help people move on with their lives. And we argue also that this is an economic development policy change that would really help people not just stay in the place that they are, but aspire to doing something bigger and better for their families and for themselves. So the clean slate policy model updates arrest and conviction record sealing for individuals who are eligible, like I said, after the 3 or 7 year waiting period. I just wanted to talk about the other states that have adopted this policy change, and they are Pennsylvania, Utah, New Jersey, Michigan, Connecticut, Delaware, Virginia, Oklahoma, Colorado, California, Minnesota, and New York. And you're going to hear from a lot of the advocates today that will talk more specifically about what this could mean to Massachusetts. It would eliminate a very antiquated process, and it would actually not, it wouldn't especially save us money, but it's not going to cost us additional money. So with that, if you have any questions, I know you're going to hear a lot about this today.
Thank you, Representative. Any questions from the committee? Seeing none at this time, appreciate your testimony.
Okay,
Yeah,
thank you very much.
I see Senator Michael Moore on S-1201, enact maintaining protective orders. And while Senator Moore approaches, I want to welcome and recognize our Vice Chair, Representative Luca Reed. Welcome, Senator.
Thank you. Thank you to the chairs and committee members for taking me out of turn. I'm here today to support my bill, Senate 1201, an act maintaining protective orders, and Senate 1204, an act updating the Commonwealth's wiretap statutes. Currently, when a parent or a guardian requests a protective order, the court is allowed to impose a range of restrictions. These restrictions ordering the defendant to refrain from abusing or contacting the plaintiff's child or child in the plaintiff's care unless authorized by the court. However, with the parent or the guardian to pass away, the court ordered affiliated with their protective order request then becomes in question. Senate 1201 would define this legally gray area by clarifying that a protective order which restricts contact with a child will remain valid even after the death of the parent or legal guardian who has filed the order. This bill also extends the protective order until it is vacated by the court, meaning there is a substantial evidence to show that the threat is no longer prevalent. A parent will do all that they can to keep their children safe. The law should uphold this commitment by ensuring that their passing does not inhibit their ability to protect their child's welfare and well-being. Senate 1204 would amend our current wiretapping statutes, which was passed in 1968, to update the technologies covered by the law and expand authority of law enforcement to use the capabilities to investigate crimes. As the Massachusetts general law currently stands, law enforcement may use a wiretap or witness to record conversations only when the crime is linked to organized crime, and only when the organized crime narrowly includes a continuing enterprise to supply illegal goods and services. This is an extraordinarily limiting set of rules and circumstances, and they very often prevent the investigation and prosecution of many serious crimes that fall outside the definition, such as hate crimes, civil rights violations, and illegal firearms trafficking. And no one can deny the epidemic we have nationally with the issue of firearm violence. This legislation would not change the extremely rigorous process a wiretap request must go through, including who may request and authorize a wiretap, as well as the existing factors and high bar of exhaustion that needs to be met in order to request a wiretap. Senate 1201 and Senate 1204 would ultimately provide our courts and law enforcement personnel with the necessary powers and tools to effectively protect the safety of our constituents. Therefore, it is my hope that these bills will receive a favorable report from the committee today. Thank you again for the opportunity to testify, and I'm more than happy to answer any questions. Thank you.
Thank you, Senator. Questions from the committee? Seeing none at this time, thank you.
Thank you.
I see Representative Linsky has joined us.
Thank you very much, Mr. Chair and members of the committee. It's a pleasure to be back here. I'm here to testify today in favor of Senate Bill 1221, filed by committee member Senator O'Connor, and then to also mention my bill, House Bill 1845, which I think you'll be getting to in a couple of weeks at a later hearing. This is an act strengthening GPS tampering law. And I have filed this bill to close a very dangerous loophole that currently exists in the way the court handles those individuals who have been ordered to wear a GPS device as either a condition of probation or parole. While tampering with a GPS device is currently recognized, it can be prosecuted. It can only be prosecuted as a misdemeanor under the malicious destruction of property statute. And that is a non-arrestable offense under the law in Massachusetts. This bill and my own House bill would create it into a separate crime, making it a felony and making it an arrestable offense. And this is extremely important. I expect that you will hear later during this hearing today from several survivors who will give firsthand accounts of why this is important. If you will, for a minute, I want you to think about why an individual has been ordered by the court to wear a GPS device, an ankle bracelet, if you will. They've been released after an accusation of crime, or they've been sentenced to probation. And they've been ordered to wear a GPS device in order to protect the public, or more frequently, to protect a specific individual. If the person who has been ordered to wear the GPS device tampers with that device, damages that device, cuts off that device, I want you to think for a minute about why that person is probably doing that. They're doing that because they intend to commit another crime. They're doing that because they intend to cause harm to the person who testifies against them. They're doing that as an affront to the court, to the criminal justice system, and to society. That's a serious offense. It should be an offense that is treated that way by the court system. It should be treated as an arrestable offense, and it should be treated as a felony. Currently, what has to happen under that situation is a probation officer has to go before a judge and request a warrant. That takes time. It's a cumbersome process. The police currently don't have the right to make an arrest without that warrant. Under Senator O'Connor's bill and under my bill, it would create a specific crime that reflects the seriousness of the offense, and it's an arrestable crime. These bills, and I would ask this committee and the legislature to act on them favorably, which recognize how serious an offense this is, would punish it in the correct way, and make it much easier for the public to be protected. I'd ask you to listen later on during this hearing to the testimony of some of the survivors who will tell you the specific circumstances that led to this, and I would ask for your consideration on this bill. Thank you.
Thank you, Representative. Questions from the committee this time? See none? Thank you. I see Leader Donato here on H 1672, who will adhere to the committee rules on turning that phone off as well. Perfect timing. Welcome, Leader Donato.
Mr. Chairman, members of the committee, I'm here to speak on House 1672. 1672 is a community connect solution that addresses enhanced victim notification envisioned by the legislation through automatic updates to the victims. This system, Mr. Chairman and committee, this system would provide an opportunity for victims who are looking for information through the district attorney's office, through the prosecutor's office, or through the courts, or even through the local police department, the opportunity to gather information as to where their case is, when their case will be heard, what is going on with that particular case, and if there are any changes, the victim would get that notification right away through this process. Over 150 public agencies throughout the country have instituted this. The Middlesex County District Attorney is in favor of this and willing to be the person who starts the program in Middlesex County and get involved with it. It's a program that is necessary for the victim because there are times, as you know, Mr. Chairman and members, there are times when a victim is told that his or her court date is November 5th, and then all of a sudden it changes, and in a lot of cases, they either get notified on time or don't get notified at all. So this legislation would provide that opportunity through the district attorney's office, provide information to the victim so that the victim has complete knowledge as to where their case is, when it's going to be heard, and whatever ramifications go on with the case. So I thank you, and I hope that the committee looks favorable on the legislation. And I apologize for the phone call.
Thank you for your testimony. Any questions from the committee at this time? Seeing none, thank you.
Thank you, Mr. Chairman.
I'll now welcome up Sheriff Patrick McDermott from the Mass Sheriff's Association on H 1897. That is an act relative to community corrections filed by Representative Frank Moran.
Yes, good morning, Mr.
Welcome.
Chair. Good afternoon, Mr. Chair, members of the committee. I'll be very brief on this. This is something that the Massachusetts Sheriffs are continuously in work in progress with our colleagues with the Commission of Probation. We haven't had a chance to really meet on this necessarily to go over what we feel is the best cooperative way to see this. But sheriffs across the state, across the Commonwealth, are consistently doing unbelievable things in reentry services. Getting very inventive on local programs, local reentry services on behalf of the constituents that we represent that are coming home after incarceration, as well as doing pretrial options. We work with the courthouse quite consistently on pretrial opportunities that prevent people from being incarcerated in the first place. And so, Mr. Chairman, we also know that there is a commission currently right now evaluating our collaboration and consolidation issues relative to the various services that are currently being utilized in terms of reentry services. So I would just recommend, we're not opposed to this bill at all. We're not necessarily fully in favor of it either, but it's one of those moments where I felt the obligation on behalf of my colleagues to just highlight that to the committee. That we are looking forward to working cooperatively with the Commission of Probation and his staff to see what we can do through the commission that's working now on collaboration. So appreciate the opportunity to testify.
Terrific. Thank you, Sheriff.
Thank you.
Any questions from the committee? Seeing none, look forward to working with you. Move virtually now to Representative Farley Bouvier, who's joined by Sheriff Thomas Bowler and Barbara Gallo on H 1685 S1238, an act relative to threats of suicide while in court's custody, and ask that they be brought up virtually. Representative, you're on mute. There you are.
Here, can you, now it's okay?
Yes.
Okay, thank you so much. Mr. Chairman, Madam Chair, members of the committee, I'm here to testify on H 1685 and Senate 1238. I'm working with Representative Brian Ash and Senator Oliveira on this bill. We filed this bill in memory of Stavry Yanka, who died by suicide in the Berkshire County House of Correction. And if I had one big message for you, is that this death, tragic death, was preventable. It was preventable because the trial courts knew that he was a suicide risk, but that information, mostly because of technical parts of how information is relayed, wasn't available. And we're just trying to make a technical change. We've also worked over the last 2 years with the trial courts and the Sheriff's Association to come up with improved language, and that's what's in front of you now as compared to what was filed last session. I'm going to keep this very brief because I want to turn this over to Stavry's mother Mrs. Barbara Gallo, so that she can tell the story of what happened, and Sheriff and I are working with her. So Mrs. Gallo, if you can unmute yourself, can you see how you can do that? No. Okay. So I would invite you to look to the top right of your screen, but in the meantime, perhaps Sheriff Bowler. Oh, Sheriff Bowler can come on. Sheriff?
I got it.
Okay.
Actually, I got it. Thank you very much.
Sure.
Thank you. Good afternoon. My name's Barbara Gallo, and thank you for the opportunity to provide testimony on the proposed law that will bear my son's name. This is my second opportunity to provide testimony on this bill, as it didn't make it out of committee on the previous attempt. Please know that I'm not going away. On December 7th of 2021, my son Stavry completed suicide by hanging in the Berkshire County House of Correction. He used his socks. I want to let that sink in for a moment, especially if you're a visualized person like I am. Less than 5 months prior to my son's death, he was seen at the Berkshire Medical Center in Pittsfield, where he's brought via ambulance for putting a zip tie around his neck. In case you're unaware, this is practice behavior and a major indicator for suicidality. My husband and I, armed with an understanding of our son's mental health and substance use, went to the Pittsfield District Court to petition for a Section 35 commitment. Some months later, my son was booked into the Berkshire County House of Correction. Though we were concerned about the events that led up to this, there was a certain relief that he would be safe from himself and his choices for a while. He was sentenced to 60 days on November 5th of 21, but instead got a death sentence to be carried out by his own hands. I've been employed by the Hampden County Sheriff's Department since mid-2008. I'm an academy-trained employee, meaning that I'm trained as a correctional officer, and I have more than a layman's understanding of how our county jails operate. Additionally, I work with families struggling with the effects of a loved one with substance use disorder professionally and as a peer for over 17 years. Over the years, I've told other family members who found themselves in my position to get a good night's sleep while their loved one's incarcerated, knowing that they're safe. This left me ill-prepared to receive the news about my son on the evening of November 7th. I wanted to blame Sheriff Bowler and his staff for not performing their primary responsibility of care and custody. When my husband and I met with Sheriff Bowler, I wanted to know why my son had the time and materials to complete this act when he had a documented suicide attempt 5 short months earlier. I felt no reason to contact the jail with any concerns, as I was secure that this information was in their possession. Sheriff Bowler told us that his office was unaware of this previous attempt, and my son's assessment didn't provide the necessary information to have him placed on a risk status. In a day and age when you can unlock your phone with your face, or I can mention buying a new car and have my social media flooded with ads for car sales, how can this be? How can we not share information as essential as this with the potential deadly consequences? Imagine caring for a child who had recently become fond of crawling out a window, unlocking and crawling out a window. Imagine caring for this child, not having this information when the child does exactly that, when you turn your back for a short moment and perishes in this act. Who do you hold responsible? How can you hold a caretaker responsible for information they don't have? Ladies and gentlemen, this is common sense legislation and a simple fix. Please spare another family from the anguish we suffer daily. I and the rest of my family will be forever scarred by that day. We are not the only ones who are dealing with the long-term effects of this. As staff at the Berkshire County House of Correction, their families, ambulance personnel, and the sheriff himself are still experiencing the effects of this 4 years later. We will not only relive the events of that day, weeks, and months leading up to it, questioning our thoughts, actions, and our training. For me, it's unconscionable that this bill has to come before you again. Its intent is simply to provide the systems. We give the responsibility to the tools to carry it out. Otherwise, perhaps upon intake into our houses or correction, we issue a piece of rope to each of the inmates as their intake. Thank you.
Thank you, Ms. Gallo, for that powerful testimony. I don't know if Sheriff Bowler is having some technical difficulties. Sheriff, are you available? Okay, well, with that, I just want to say that, yes, over the last 2 years, we have worked between the trial courts and the Sheriff's Association to get the language right. And very important for this committee, the trial courts believe strongly that this change has to be made in statute, which is why we continue to be here. So with that, I thank you for your time, and we are certainly available for any questions.
Thank you. Before I open up to questions, I want to turn to Senator Edwards.
Thank you. I just wanted to note that one of our committee members, Senator Liz Miranda, has joined us.
Trish, can you hear me?
I can hear you. You're not seeing you.
Yeah, Sheriff, you got about 20 seconds if you wanted to add anything there. All right. With that, I'll ask any questions from the committee.
No, can you hear me?
Sheriff, you got about 15 seconds.
Yes, sir. I just wanted to say thank you for letting us, hearing us today in this committee. As a result of our last testimony, it was determined that we needed to really shore up the whether or not this should be a law. It was a great collaborative effort between EOPS, CJIS, the mass sheriffs, and the trial courts. It is definitely a life-saving tool or mechanism that we are going to need in order for us to do our jobs efficiently and effectively. So with that, we're hoping that we ask for a favorable report coming from the committee. Thank you, sir.
Thank you. We look forward to working with the representative and the Sheriff's Association and the courts on this issue. Appreciate the testimony.
Thank you.
I'll now welcome District Attorney Quinn from Bristol County, who I believe is virtually here to testify on H 1691, an act relative to certain offenses, followed by Representative Viola. District Attorney Quinn.
Says everything.
While we're pulling the district attorney up, I would remind folks when you testify here, that microphone doesn't amplify the room, but it does help with folks watching virtually. So please pull that microphone over to you. DA Quinn, welcome. I believe you're muted. I guess we'll come back to DA Quinn. We'll be in touch offline to try to get him online. We'll move on now to consideration of S 1215, an act providing a defense to prosecution for violations of the wiretap law or interceptions made to make corrective threats, harassment, or other crimes, and S 1222, an act relative to GPS tampering. And welcome up a panel headed by Senator O'Connor, welcoming Joelle Riddell and Shauna Fopiano with welcome on.
Thank you, Mr. Chair, and through you, Chair Edwards, and to the fellow members of the committee. We appear before you today to testify in support of Senate Bill 1221, 1222, which are relative to GPS tampering statutes, and Senate Bill 1215, which seeks to create a carve-out in our wiretap laws. I'm very honored to be joined here by two incredibly brave constituents, Joe from Hingham and Shauna from Marshfield, and both of their tenacity and strength has been really inspiring. I'll start with GPS tampering. This legislation aims to prohibit tampering of GPS monitoring devices. One of the bills would impose a mandatory minimum sentence of 2 years in state prison for offenders, and the other one, followed in collaboration with Representative Linsky, would provide judicial discretion in classifying the offense. These GPS devices play a vital role in ensuring the safety of our communities, especially victims and survivors of domestic violence and vulnerable children who have been victims of sex crimes and other abuse. We've seen dire consequences when those sentenced to wear a GPS device tamper with it. Murders, rapes, recidivism, stalking, kidnapping, and the list goes on and on. We cannot overlook the dire consequences that arise when individuals manipulate or destroy these monitoring devices. The safety and well-being of our communities, especially the most vulnerable among us, are at stake. California, Illinois, New York, and many other states have filed and made GPS tampering a felony for these exact reasons. Shifting gears to Senate Bill 1215, this would provide a defense against wiretapping charges for making recording of threats, harassment, and other crimes. In the years since I've filed this, I've learned from this issue, and we've heard from dozens and dozens of victims who've undergone similar injustices. For many of these individuals, recordings of the abuse that they have endured is their only means of getting the evidence that they need in order to prove their claim and in many cases protect their lives. This evidence can be the deciding factor in getting a restraining order or emergency protective order against their abuser or to get their children out of harm's way. We've spoken with dozens of family law attorneys, members of the family law section of Women's Bar Association, the Boston Bar Association, Jane Doe, and Legal Services Office, who have all shared personal experiences with how this outdated law directly obstructs justice and enables abusive litigation. We've spoken with district attorneys who agree that this law is being used right now to intimidate victims of abuse into staying silent. This evidence can give a victim the protection they need to escape a horrific situation, protect a child from going home to an abuser, and in some cases, save their lives. This bill is a modest, common sense, narrowly tailored carve-out of our wiretap statute to protect an extremely vulnerable population from enduring further trauma and abuse. It is now my honor to introduce Shauna Fopiano.
Hi, my name is Shauna Fopiano, and I am testifying in strong support of the proposed amendment to Section 99 of 272, the law on wiretap. On August 2nd of 2020, I obtained a restraining order after fleeing my home with my daughter, who was 1 at the time. That restraining order is still in place today, over 5 years later. In the months leading up to that day, I made 8 recordings on my phone of things being said and done inside my home. Those recordings were played in family court during the 2-day evidentiary hearing to extend the restraining order and included a discussion about why this person had threatened to peel off my daughter's fingernails with pliers, a statement about strangling her, calling her a terrorist, and saying it was too swear word bad if this barely 1-year-old was hungry. I found myself in a situation that I had never expected or wanted, and I originally started recording not knowing it was illegal because I couldn't make sense of what was happening. Towards the time I left, I was recording because I thought there should be evidence if something were to happen to me and because I was worried people wouldn't believe me. A few months after that restraining order hearing, the same person in the recordings filed a criminal complaint after police declined to pursue charges against me and a clerk magistrate allowed it to proceed. The Plymouth County DA then chose to prosecute me. Instead of being protected, I walked into the Plymouth courthouse as a defendant, having never been in trouble with the law before, facing 8 felony counts of unlawful wiretapping and up to 40 years in prison, and was arraigned. I had no defense as to why I did it because the current law doesn't allow for one. Under the current version of this law, someone who is assaulted, threatened, or even killed, who seeks help, who fears for their life, who does what many survivors are told to do, document the abuse, can instead be prosecuted and criminalized. Ultimately, I was placed on pretrial probation and the charges were dismissed, but the impacts are lasting. My trust in the system has been impacted and I felt my life was over at the time. I thought the system would protect me and it did the opposite. The law as written does not serve justice. It endangers survivors and it silences truth. I urge you to amend this law so no one else in my position has to suffer what I did simply for trying to protect herself and her child. Please let Massachusetts be a state that listens to and defends survivors, not one that prosecutes them for speaking the truth. Thank you.
Good afternoon, Chair Edwards. Thank you, Senator O'Connor and Representative Linsky, for all of your support. My name is Joe. I'm a mom, friend, nurse, and a survivor of domestic abuse. I come here again today to advocate with others to share our stories in hopes that you will listen and hear the realities of what goes on in our world of domestic violence and the realities of GPS tampering. As elected officials with the power, I implore you to help make much-needed change by making it a crime to tamper with a GPS device. Please protect victims, help keep our communities safe, and improve the integrity of our court systems. GPS bracelets are given to offenders who have proven themselves to be an imminent threat to their victims. For those brazen enough to cut off a GPS, there should be serious consequence. There are reasons abusers tampers with the GPS. The reason is often to go get their victim. Please understand this. My abuser hit me, spit on me, threatened the well-being of my children. He had multiple probation violations, multiple restraining order violations, and then he cut off his GPS at Logan Airport. He told probation a TSA agent cut it off. Probation accepted this bogus story. In fact, the chief PO told me she knew it was TSA because it was, and I quote, a clean cut and done with special scissors. The director of security at TSA told probation the story was ridiculous. I needed to go in and out of Hingham Court begging for protection, knowing now my abuser had control of the system, a system that seemed to disregard my life. Ignorantly, I expected the court to help protect me. But even after my abuser admitted to cutting off his GPS with pliers, he was not punished. In fact, the same judge that did not extend probation or punish him for cutting it off denied me another restraining order and said that my fear ran its course. 10 months later, he followed me. Message received. Abuser gets another chance. My protection gone. He is empowered. The courts failed. No justice. I'll sum it up by saying, could you please stop giving abusers chance after chance and give victims a chance to live safely? Please pass Senate Bill 1222 and make tampering with a GPS a crime. Thank you.
Thank you both for your personal testimony, Senator. Thank you for bringing them up. Questions, Representative Sullivan, on it.
Thank you, Mr. Chairman. Senator, have you had any conversations with the DA's office regarding the wire law when it comes to victims of domestic violence?
We have. We've spoken with the District Attorneys Association, and I believe that we're scheduled to be in there next month to present to the district attorneys. But this has been something that we've heard from individual district attorneys, not to name them, but we do have support from many of our district attorneys right now, but we're trying to get the coalition to join
To get
us.
behind it, okay, yeah, because I know our district attorney, I believe, is in support of this. I've had several conversations regarding it, on the frustration of having to prosecute, not having that discretion to not prosecute. And I want to thank you both for sharing your stories. It takes a lot of courage to get up here and speak on a personal story, especially one that you've been, I think, in front of this committee. I think, Joe, this is maybe your 5th or 6th time testifying, and I appreciate you coming before us. Hopefully this year will be different than the last when it comes to protecting victims of domestic violence. So thank you.
Thank you, Representative. Any further questions at this time? Seeing none, thank you both for your testimony.
Thank you, Chairman.
Staying with S 1215, we'll virtually welcome April Bradshaw, now present at this time. Maria, now present at this time. Kelsey Forrest, also not present at this time. We'll try to loop back at the end of the hearing for those individuals. On S 1222, an act relative to GPS tampering, we have Taylor Walsh. Welcome.
Good afternoon, Chair Day and the committee. Thank you, Senator O'Connor, for your support. Thank you, Representative for your support. And Chair Day, thank you for your time. My name is Taylor, and I'm a domestic abuse survivor. My current abuser is currently incarcerated, convicted of 5 or 6 counts of felonies with all abuse towards me. He abused me for 6.5 years, and on July 21st, 2022, that was it. That was enough. He smashed me in the back of my head while I was asleep, and my, at the time, 3-year-old daughter was asleep a few rooms down. This is the second time I've spoken in front of the committee. My abuser is currently going to be released this coming year, and this is very important as he's had a GPS monitoring system before. He attempted to cut it off. He violated probation multiple times. Probation failed me. The court system failed me after his 6 felonies and his pretty much attempt to really seriously harm me in my sleep. He was given off with a stop on the wrist of 18 months probation with the GPS monitoring system. The only reason he's currently incarcerated today is because he repeatedly violated probation. I am very afraid that when he gets out, if he does not have a secure GPS monitoring system, that he will absolutely try to find me, communicate with me, and possibly harm me worse than he has in the past. I would really appreciate and like this bill to be passed, as this is the second time I've been here, and I feel like this is a no-brainer. If anybody's both brazen enough to tamper with a GPS monitoring system, that means they're brazen enough to go back and harm somebody that they've already harmed and tortured for over 6.5 years. That's all I have to say.
Thank you. Ms. Walsh, any questions or comments? Seeing none at this time, thank you for your testimony and sharing your story again. Welcome up Tara Croteau, sorry. Welcome.
To the honorable members of the legislature, my name is Tara, a survivor of domestic violence. I'm speaking to express my strong support for the proposed amended bill 122 Act relative to GPS tampering. This legislation is an important and necessary step towards ensuring the safety of victims, particularly those affected by domestic violence, stalking, and other crimes where offender monitoring is crucial to public and personal protection. My abuser was required to wear a GPS monitoring device back in 2016. Despite this, he continued to abuse me while wearing it and deliberately attempted to disable the device. Specifically, he damaged the charging cord right next to the GPS device charging port while I was at his house against my will. The monitoring company contacted him by phone, and he informed them I was there. They then spoke to me and instructed me that I had to remain there until the device could be replaced the following day. Required a 45-minute drive to do so. During that time, he was effectively off the grid for more than 24 hours. Throughout that night, I was terrified, physically sick with fear, and subjected to continued abuse. Despite clear evidence of tampering, there was no punishment, only a replacement of the device and release of the offender. He later learned how to remove the device entirely and even taught his young son, who subsequently informed his mother. There should have been consequences, some form of accountability for tampering with the GPS device. This bill that addresses that critical gap. I support Bill 1222 because it holds offenders accountable. Tampering with GPS devices is not only a violation of court orders, but also puts victims in immediate and significant risk. This bill reinforces the seriousness of such violations. Many victims rely on GPS tracking to feel safe. Tampering undermines the integrity and reliability of the system. Criminalizing these acts sends a clear message that interference with victim protection will not be tolerated. Early intervention is vital. By penalizing the attempts to tamper with GPS devices, this legislation enables law enforcement and courts to act before the situation escalates into further violence, harm, or even death. Clear legal consequences will also serve as a deterrent, encouraging offenders to comply with the order restrictions and promoting public safety. Additionally, this bill supports the justice system's reliance on GPS data to make informed decisions regarding release, the supervision, and protection of the community. This legislation is more than just a legal reform. It is a crucial matter of life and safety for individuals who depend on GPS monitoring for their protection. I strongly urge the legislature to pass this bill and continue to strengthen protection for our most vulnerable residents. I just want to say he went to prison for 8 years, got out and violated
wanted within 3 months of being out. So he's currently back in being held, and I report tomorrow in Superior. And I'm hoping that this bill is passed and we can get him on the GPS for his remaining 4 years probation. So we continue to live hopefully and safely. I appreciate it.
Thank you for your testimony. Questions or comments from the panel at this time, or committee?
Thank you.
Seeing none, I do want to note too, your stories do have an impact. We were able to move a larger bill last year that did include GPS tampering provisions in there. We'll continue to work on it to try to get over the finish line, but thank you all for your personal testimony.
Thank you very much.
Appreciate it. On the same bill, we'll now move to virtual testimony. We have 3 individuals. We'll start with Sarah, not present at this time. Jack Mannion, also not present at this time. And on S1221, enact strengthening GPS tampering laws, also from Senator O'Connor. Sarah Blatchford from the South Shore Resource and Advocacy Center, not present at this time. Okay, we'll move to testimony on H1828, S1039, S1235, an act relative to due process filed by Representative Long, Senator Collins, and Senator Olvera. And there are 2 panels scheduled. We'll first welcome Tim Mascop, John Nelson, and Tim King.
Top of the afternoon, Senator Edwards, Chairman Day, and other distinguished committee members. My name is John Nelson. I'm the first vice president for the legislative chairman for the Massachusetts Coalition of Police. I'm also here as a representative of the Mass Law Enforcement Policy Group. As the good chair said, I'm submitting written and testifying favorably to the committee on the following bills: House Bill 1828, Senate Bill 1039, Senate Bill 1235, all relative to due process, and House Bill 1992, sponsored by Representative Sylvia, an act relative to body-worn cameras. Massachusetts Coalition of Police respectfully requests that this honorable committee vote these 3 bills on the due process, 1828, 1039, and 1235, out favorably. The proposed legislation is a simple technical correction to Mass General Law, Chapter 6E, Police Reform Law, and its proposed legislation is as follows. Chapter 6E of the General Law is amended by adding the following sentence after the second sentence in Section 10. For all decisions of the Commission resulting in a suspension in excess of 2 weeks or decertification of Chapter 30A appeal shall include a de novo review. The Massachusetts Police Reform Law is complex legislation that was passed during the height of COVID. During the debate, assurances were made that a full 30-day hearing were included in the proposed legislation, which included a judicial review based on the facts of the case. A de novo review hearing is necessary to provide the officers with substance due process because there is no place in the reform law that provides for a neutral decider of the fact. It was understood at the passing of the bill that a 30-day hearing to allow a judge to consider facts of the case was included as part of the process. What ended up in the final version was administrative 30A, which only allows the court to determine the commission following their own rules and make a final determination of the officer's certification. Police officers deserve due process in the decertification process, and the simple correction accomplishes that goal. Massachusetts Coalition of Police and the Mass Law Enforcement Policy Committee respectfully request that this very important legislation be voted out of this honorable committee favorably.
Tim?
I'm also, John said it eloquently enough. It's just important that, there is this de novo hearing so that currently it's just an administrative hearing and the court can only look as to whether or not the host followed the rules that they created. We want to be able to have the facts of the case be presented to a Superior Court judge so they're aware of the entire case and not just an administrative hearing.
Perfect. Thank you, Mr. King. Questions from the committee at this time? Seeing none, thank you both.
Thank
you for the work. Second panel up, we'll also welcome from Mass Cop James Keneally and from the State Police Association of Massachusetts, Chris Johnson.
Boston Police.
Boston Police, I get it. Oh, so your dad notes.
We like,
The BPPA will welcome.
we like the mascot guys. Good afternoon, Chair Day. Probably can use these instead of the sunglasses. Chair Edwards, esteemed members of the judiciary. For the record, my name is Jamie Keneally. I'm a proud active duty member of the Boston Police Department, the legislative director of the Boston Police Patrolmen's Association, and a proud member of the Massachusetts Law Enforcement Policy Group. Like my colleagues, we are here today to provide testimony in support of Senate Bill 1039, Senate Bill 1235, and House Bill 1828, all acts relative to due process. Now, I think it's safe to say, and I think few would disagree, the level of oversight and scrutiny on law enforcement in the state of Massachusetts has never been higher. In fact, in Boston alone, we have not one but two oversight boards. Of course, we have the Post Commission, and in Boston, OPAT, the Office of Police Accountability and Transparency. So the oversight, again, has never been higher. Consequently, the likelihood of a police officer losing a career or to be decertified also has never been higher. And to be clear, we're not complaining about the added scrutiny. We're not complaining about the added oversight. In fact, we appreciate both of them. But we are saying this, in addition to the added and heightened oversight, there should be a robust appeal system. Because if we're going to fire, suspend, terminate, decertify police officers, it's imperative that we get it right. Best way to ensure that we get it right, of course, is through an independent review of the facts. I think we all know that to be a de novo review. It's something we strongly believe every police officer deserves, and it's why we're here today to provide testimony in support of Senate Bill 1039, Senate Bill 1235, House Bill 1828. And again, I thank you for your time here today.
Thank you, Mr. Keneally.
Good afternoon, Chair Day, Chair Edwards, and all distinguished members of this committee. My name's Sergeant Christopher Johnson of the State Police Association of Massachusetts. Proud to sit next to my brother from the Boston Police Association, Patrolmen's Association, Jamie Keneally, and obviously with Mass Cop who preceded us. Again, echoing the same comments of Jamie, due process is fundamental to our criminal justice system. It's fundamental in the administration of public policy. It's fundamental in the administration of discipline. What we're asking, again, is just for the de novo review aspect. Post right now is limited in the decisions that they can make due to the limitations on the information that is made available to them. The de novo review by a Superior Court judge will allow that judge to investigate all of the facts, not just what was sent over to Post. I want to personally thank Representative Long, Senator Collins, and Senator Oliveira for filing this legislation that's important to our association and really important to all law enforcement members in the Commonwealth of Massachusetts. I really have nothing else to say, but happy to take any questions if anyone has them.
Thank you, Sergeant. Any questions from the members of the committee? Senator.
Question. Good to see you both. And I would say to both of you, I know. Thank you for your
Good
service.
to see you, Senator.
Good to see you. I had questions now. The 1039 applies to the Post. Does the other bill apply to OPAT or to the OPAT?
My understanding is they all apply to Post.
Excuse me?
My understanding is that they all apply to the
They all
Post
do.
Commission.
Okay. And so my question then is, you're seeking a 30A appeal to Superior Court, which is what happens from traditionally all agencies and so on and so forth. While this appeal happens, is the suspension reneged? Is the person, what's happening if the person is suspended?
I think it would depend on the situation. As the legislation is currently written, it's any suspension over 2 weeks. So any suspension under 2 weeks, essentially, they would not be entitled to a de novo review. We would hope that we would have some, that the speed of the process would come into play, and we hope that, an individual who was wrongfully suspended or wrongfully decertified would at least be made whole through the agency itself.
Let me, if you don't mind, just to clarify the question. So if I'm suspended, I get a ruling from the Post or the, that I am to be suspended for 2 weeks and a day. Am I then to serve my 2 weeks and a day, or I appeal is my question, and I'm not suspended pending that appeal?
As I understand the legislation, there's no mechanism that would essentially.
Stop that.
Yeah, there wouldn't be like an emergency stay order.
Okay.
It would just either validate or invalidate that suspension.
Thank you. That was my question.
Perfect.
Vice Chair, agree.
Thank you, Mr. Chair. Thank you, gentlemen, for being here. I just have a question, and feel free to get back to me if you have to look this up. But what does the data show in terms of the volumes of disciplinary action, whether it be suspensions or loss of ability to serve, pre this legislation and post this legislation? I guess I'm just kind of curious to better understand how big is the problem that you're trying to solve for, comparatively speaking.
I don't know if it's a problem. I think, again, it's a question about basic fairness. In terms of numbers, I would have to get back to you on that. But again, for us, the stakes are high. We just want to make sure that if a decision is made, punitive decision is made, that police officers have the right to appeal that decision. So in terms of data, again, I would have to follow up with you on that.
Well, certification wouldn't have been an issue prior to the passing of this legislation. The certification aspect was new to the police reform law. So prior to that, it was more of a question for civil service. Was it termination valid or was it invalid? And that question could be answered at the Civil Service Commission. The additional layer of a certification process, well, that a member might come back to work per se as a result of a favorable Civil Service Commission decision, but that he or she would not necessarily be immediately recertified. And that's what we're trying to address here with an overall review.
Okay. Thank you for clarifying. I look forward to the data.
Thank you, Brett.
No further questions? Thank you.
Thank you again.
Move now to testimony on H 1873 S 1284, an act relative to the interception of wire and oral communications filed by Representative Markey, Senator Vallis, and welcome up Cade Crockford from the ACLU of Massachusetts. Welcome.
Good afternoon. My name is Cade Crockford. I'm here testifying on behalf of the American Civil Liberties Union of Massachusetts. Thanks for your time, chairs and members of the committee. I'm here today to testify against a slew of proposals to expand the state's wiretap statute. Today, we are living in the golden era of mass surveillance. If there's a problem for the legislature to address in this area, we believe that it is actually the right move to further restrict law enforcement surveillance instead of to grant police new authority to violate our privacy in the most extreme way imaginable by wiretapping our phone calls, installing bugging devices in our bedrooms, in our kitchens, in our offices. Today, police have technology that 20, 30, 40, 50, 60 years ago was just science fiction. All over the Commonwealth, there are license plate readers that are tracking everywhere we drive, not just people that are suspected of crimes, but every single one of us. There is currently no state law that limits how long this information can be retained or how it can be used. All of us carry these tracking devices with us in our pockets 24 hours a day. I even carry mine to the bathroom. I'm somewhat ashamed to admit. Police can get a warrant to find out where we were last week, last month, last year, simply by serving legal demand on our phone company. Police can also access, sometimes with warrants, sometimes with a mere administrative subpoena, which is essentially the prosecutor's equivalent of a prescription pad for a doctor. No judge ever sees or authorizes those subpoenas. They simply write down on a piece of paper, we would like these records, send them to your phone company, and can get records of every person you've called, how long those calls lasted, financial information, many other very sensitive records. So I could go on and on. The point is, police have tons of access to all sorts of information with and without court orders, with and without warrants, stored communications, access to our emails, pretty much everything you can imagine that's in our devices and more is available to law enforcement to investigate serious crimes. So we believe the legislature got it right when they limited this very extreme form of surveillance, again, listening to our private conversations in our homes, in our offices, in our cars, on the telephone, to situations in which prosecutors can demonstrate that there's a high level of coordination among disciplined criminal groups. So we would ask the legislature to preserve the wiretap statute's limitation to organized crime, and to reject these proposals to expand the wiretap statute. I would only say, in addition to that, that we have very serious concerns with respect to the bills that would expand 58A. There are racial justice concerns here. There are fundamental due process concerns related to expanding the categories and the scenarios in which prosecutors can ask courts to hold people without a showing that they're guilty of a crime. Thank you so much.
Thank you for your testimony. Questions from the committee? See none, thank you.
Thank you.
I'll move now to H 1935, an act relative to wiretapping in the Commonwealth, filed by Representative Phillips. And welcome up Christina Pierce. Christina Pierce. All right, we'll move to Lisa Fontes, who's here virtually.
Yes, hello.
Welcome, go right ahead.
Okay, thank you very much. Members of the Judiciary Committee, my name is Dr. Lisa Fontes. I have a PhD in counseling psychology. I teach courses on child abuse and sexual violence at the University of Massachusetts and at Smith College. I have worked as an expert witness on dozens of legal cases concerning coercive control, domestic violence, and child abuse in the Commonwealth and across the country. I see how our current wiretapping law impedes protection and justice for adult and child survivors in the Commonwealth. Sometimes a recording of an abuser's threats is the only evidence that a survivor has of the violence and abuse that has occurred behind closed doors. Earlier this week, I started working on a case in another state. On a phone call, the domestic violence survivor challenged her children's father, who she was separated from, about multiple times he had whipped the children with a belt. These are young children. The children had kept the whippings secret from her because they had been threatened that they would be punished worse if they told. On the day they revealed the abuse, this mother took the children and fled to safety. In the recordings, the abuser admitted to whipping the children. In that state, the victim doing the recording cannot be prosecuted for making and using the recording. The recording helped this protective mom keep her children safe. The father's access to the children will be supervised until he learns how to be a more empathic and kinder father, so he will stop abusing these young children. I want Massachusetts domestic violence and child abuse victims to have the same protections as vulnerable people in other states. Members of the committee, I beseech you to pass this legislation. I sincerely believe that no one should be prosecuted for collecting evidence to protect themselves and their children. Thank you very much.
Thank you, Dr. Fontes. Any questions from the committee members? Seeing none, who's that phone coming from? Us?
It's like a landline.
Thank you, Dr. Fontes. Seeing no questions, appreciate the testimony.
Thank you.
Move now to S 1204, an act updating the Commonwealth's wiretap statutes. And welcome virtually Sophia Armstrong.
Hi.
Welcome.
Thank you. So here I am today to testify to lift the wiretapping law. I am a survivor of domestic violence, and over a year ago I got caught off guard. It put me into a very bad depression. At the time I'm sitting on the stand, and I got the choice of giving my Fifth Amendment up or taking a felony over an abuser. At this time, this abuser has a 17-page rap sheet and is a felon. I think this should be listed because the only chance you have is someone abusing you, and the only chance you have is your phone. We're in 2025 where everybody uses their phone, everybody takes pictures of people, everybody videos people. And at the time I got completely caught off guard that was even a law. So at this time, I was sitting on stand and again, pregnant at the time, and this put me into a deep depression where at the time I gave birth to my daughter postpartum because of the stress. I was worried about catching a felony with somebody who was on an ankle bracelet, somebody who was on a GPS, stuck at home on house arrest, and the only option I had was to record. To this day, I still am dealing with the consequences for it. I gave birth in January. 2 days after, I had to go extend a restraining order, and I was terrified of bringing this up because it was a case that got dismissed because I gave my Fifth Amendment right up. At this time, this person has 4 to 5 different restraining orders, and one is from a Weymouth police officer. So at this time, I really wish this could get lifted for people to understand that abuse, dangerous situations, my kid was in a dangerous situation. I just wanted to be the best mom I could be. And I thought recording was the best option, but instead it put me into a deep depression. It put me into flight or flight mode. I believe that a lot of women go through this, even men, and especially that we're in 2025, this should definitely be a lifted rule. Definitely if they have a record of prior violence, prior felonies, dangerous person. So that is my testimony. Thank you.
Thank you for sharing your testimony with us. Any questions from the committee at this time? Seeing none, thank you again for sharing your story. I'll move on now to enact H 1654 S 1063, an act to enhance the rights of crime victims in the Commonwealth, filed by Representative Decker and Senator Sear. And welcome up Liam Lowney from the Massachusetts Office of Victim and Witness Assistance. Sorry. Welcome.
Thank you. Good afternoon. Chair Day, Edwards, members of the committee, thank you for hearing my testimony today. I'm Liam Lowney, I'm the Executive Director of the Mass Office for Victim Assistance. I'm testifying today on behalf of the Victim and Witness Assistance Board on a bill that we've filed for a few sessions now to enhance the rights of crime victims. We're really trying to modernize a law that's existed since 1984 and trying to make some updates. This legislation is the product of several conversations over years with victim service providers, law enforcement, and other stakeholders in our system. Crime victims have the right to be informed, present, and heard in the victim rights law. We know that, and this bill seeks to enhance and modernize some of those priorities. Increasing access to survivors with limited English proficiency to our court system. Codifying that agencies throughout the life of a criminal matter have a responsibility to provide updates to crime victims on matters and cases that involve them. Ensuring that victims of homicide and sexual assault have access to a victim witness advocate regardless of whether a case has been charged or an individual has been identified. And ensuring that victims have a right to be notified prior to release from bail so that survivors can make decisions about their safety. Now, the role of the survivor voice in the criminal legal system is imperative. We see time and again, and we see it today, the impact that the survivor voice can have on our policymaking, but also on our criminal legal system. And the victim impact statement is the one time in the court case that it's actually about the victim. The court regularly hears from victims and survivors as they fashion a sentence. However, over time, with competing interests, our busier courts cases can get resolved without the real opportunity for a victim to be heard. So this bill seeks to add some clarifying language to ensure victims are afforded the important right. Finally, we have a technical fix in it to try to expand the definition of family as it is here in 2025 and not as it was in 1984. So we think that's important too. So with that, I will turn it to you for any of your questions. Thank you for your time, and I will be able to report this out favorably.
Thank you for your testimony. Any questions, comments from the members of the committee? Seeing none, thank you, Ms. Long.
Thank you.
Welcome up Pace McConkey Jr. from the Lewis D. Brown Peace Institute.
Thank you, Chair, and members of the committee. Thank you for this opportunity to testify in favor of H 1654 S 1063, an act to enhance the rights of crime victims in the Commonwealth. My name is Pace McConkey Jr., and I speak today on behalf of the Lewis D. Brown Peace Institute, a nonprofit organization that serves families and communities impacted by homicide all across the Commonwealth. The Peace Institute was founded in 1994 when 15-year-old Lewis Brown was caught in a fatal crossfire in Dorchester. Shortly after his death, but not until news of Lewis's good moral character was made public, were resources for his surviving family made abundant. This exposed the harsh reality that the rights and resources afforded to victims of crime were in practice conditional to the assumptions made about the victim's character, and often the stigmatization of the crime itself. This contributes to a non-equitable distribution of rights given to victims of crime, which disproportionately impacts victims of color, their families, and victims found at the intersection of violent crime, racism, and poverty. The rights of victims and witnesses of crime, as outlined in Chapter 258B of the Massachusetts General Law, sets the precedent of how victims of crime should be treated in the Commonwealth. Any ambiguity or lack of specificity in its language leaves space for key stakeholders to exclude rights, resources, and care from victims of crime. This bill, an act to enhance the rights of crime victims in the Commonwealth, provides much-needed updates, such as modernizing the definition of a family member, clarifying who needs to be notified with sentencing and case disposition, and sets up a commission to study victim impact. These updates will better ensure that all victims of crime and their families are ensured the same rights under the law. It gives advocates such as our team at the Peace Institute the standard to hold law enforcement, hospital workers, and other important stakeholders accountable when serving families impacted by homicide. This is an issue that impacts all of us. At the Peace Institute, we understand that for each homicide, there are a minimum of 10 people directly impacted by that loss. It's notable that since the year 2000, homicides have occurred in 186 different cities and towns across the Commonwealth, causing the number of survivors of homicide victims statewide to grow exponentially year after year. I ask that this committee strengthen the rights of its survivor constituents by reporting favorably on this bill so that we can better meet the needs of victims of crime and their families all across the Commonwealth and honor the rights and privileges they're entitled to. Thank you.
Thank you, Ms. McConkey, for your testimony. Any questions from the committee at this time? Seeing none, thank you again.
Thank you.
Move on to consideration of H 1525, an act relative to community corrections, followed by Representative Frank Moran, and welcome up Vincent Laurenti from the Office of Community Corrections. And as Mr. Laurenti approaches, I want to welcome and recognize Representative Mendez, who's joined us as well.
Thank you, Chair Day. Thank you, Chair Edwards, and the members of the committee. My name is Vincent Laurenti. I'm the Executive Director of the Office of Community Corrections. I'm here on behalf of Commissioner of Probation Pamerson Eiffel and the Mass Probation Service to testify in support of the bill, an act relative to access to community corrections. I extend our thanks to the entire committee for your thoughtful deliberation on these matters. Thank you to Senate. I'm sorry, I already said that part. I also want to extend special thanks to Representative Frank Moran and Kate Lipper-Garabedian and Senator Will Brownsberger, who have all been vital advocates for our office in this bill. The Office of Community Corrections was created to make communities safer and stronger. We understand that jail and prison are an important component of the justice system, but we endeavor to provide meaningful, effective options so that incarceration is an absolute last resort. Communities are safer when people are empowered to make new positive choices. Communities are stronger when all their natural members are present, whole, and accountable rather than in jail or prison. The bill before you builds on the criminal justice reform of 2018 in important ways. First, it changes the name of our office from Community Corrections to Community Justice Programs, thereby reducing the stigma that clients associate with corrections. Second, it creates statutory protections so that individuals in the pretrial programs cannot have information that they disclose in program used against them in the pending case. Third, it further codifies the authority of the OCC to develop and deliver services to people that have been justice involved after their supervision ends. And finally, it expands eligibility for sentencing to intensive supervision with treatment so that all people on probation can be sentenced to it. The bill changes, the bill changes the name of our office to the Office of Community Justice Programs, thereby embracing the principles implied by community justice. First, while punishment is part of justice, our system must equally focus on solving the underlying problems that contribute to crime. Our system must partner with the community to understand those problems and to shepherd resources to solve those problems. And resources should be invested and deployed where people live and work. Community justice is an important element of justice reform that has the power to reduce racial disparities, minimize traumatic impacts of incarceration, and increase access to treatment and save the Commonwealth money for other priorities. I'm hopeful that the passage of this bill will better position us to achieve these positive outcomes. Thank you all for your time. Should you have any questions, obviously I'll take those questions now, but you can also reach out to me offline. And it would also be my privilege to offer any of you a tour of one of our community justice support centers near you.
Thank you for your testimony and work. So much appreciate both. Any questions from the committee? Seeing none this time, thank you. I'll move on now to consideration of testimony of H 1691, an act relative to certain offenses filed by Representative Fiola. And welcome from the Committee for Public Counsel Services, Jeff Garland. Leave his virtual.
Good afternoon. I hope you can hear me.
We've got you. Go right ahead.
Thank you. My name is Jeff Garland. I'm a public defender with PCS, and I'm appearing in opposition to the expansion of so-called dangerousness detention under H 1691 and S 1220 and S 1271. The press is always quick to highlight the harm caused by someone on release, but gives little attention to the harms caused to many people incarcerated who wouldn't have committed any crimes while their case was pending, even though these harms are also very real. They include psychological harms, subjection to violence at the hands of staff or other incarcerated people, the loss of a job, the loss of housing, and the vicarious harms to their children and their families, all of which also make everyone else unsafe by increasing the likelihood of crime in the future. For instance, one study found that pretrial detention caused a 35% increase in rearrest for a new crime post-disposition. Even just 3 days detention, the time Section 58A allows the Commonwealth to detain someone before a hearing, can lead to a significant increase in rearrest after release. These harms also fall harder on Black and Hispanic people, who in Massachusetts have 58A petitions filed against them at roughly 2 to 3 times the rate against white people. One study in New York City, for example, found that because pretrial detention increases both the likelihood of conviction and the length of a sentence, it alone explained for 40% of the Black-white gap in rates of being sentenced to prison and 28% of the Hispanic-white gap. The SJC has upheld the constitutionality of Section 58A detention because it has time limits and a limited number of particularly serious crimes as triggering predicates. But these bills would remove these time limits or expand the predicates to include a number of lesser crimes. And even some more serious sounding crimes often provide little reason for detention on dangerousness. For instance, assault and battery on a police officer often in practice may involve just someone raising their hands as they're being arrested, or in some cases not doing anything at all except being tackled by the police. Malicious destruction of property can be a misdemeanor and often ends on probation. And while I can understand the temptation to include statutory rape, because all child rape is serious, it's in the most serious areas where due process is most important. Many defendants do turn out to be not guilty. And in the meantime, the probability of new offenses in these cases is actually extremely low, because child rape cases are usually crimes of opportunity among people who know each other, and the opportunity disappears once they're criminally charged. One of the bills would allow prosecutors to appeal the release of a defendant, which we oppose, and also allow the Commonwealth to move for dangerousness at any time, which would be even more destabilizing. Thank you.
Thank you, Mr. Garland, for your testimony. Any questions from the members of the panel or committee at this time? Seeing none, thank you.
Thank you.
Move on now to testimony and consideration of H 1693, an act to remove collateral consequences and protect the presumption of innocence followed by Vice Chair Fluker Reed. And welcome up first a panel from the Coalition for Social Justice Action, Marlene Pollock, Adrian Thompson, and Deshawn Couch. Welcome.
Thank you very much, Chair Day and Chair Edwards and the Joint Committee on Judiciary for holding this hearing. My name is Marlene Pollock, and I'm from the Coalition for Social Justice Action Fund from New Bedford, Fall River, Brockton, Taunton, and the Upper Cape. We have endorsed 1693, an act to remove collateral consequences and protect the presumption of innocence. This bill would provide immediate sealing of a criminal offense at the time of the final disposition if the case ends favorably without a conviction. That means any dismissals, drop prosecutions, bogus cases, and dismissals after continued without a finding would result in the immediate sealing of the record. Common sense tells us that the decision of the court not to prosecute or dismiss a case should mean that the person can get a job, housing, or participate in their communities. Unfortunately, this is not the case. Even dismissed cases drive poverty and mean a person can't volunteer at their children's school or go on field trips. Once records are sealed, this bill would make it easier for individuals to get access to their own records without having to file a motion to unseal them. Quick access to their records would help people with immigration hearings and other purposes, such as a job with high security clearance where the employer gets special access to sealed records. Thank you.
Thank you. So I want to thank the committee for taking up consideration of this bill, H1693. I'm Adrian Thompson. I work for Marlene Pollock for the Coalition for Social Justice in New Bedford. So I brought my record, my Corey. It's 15 pages. And to be fair, I'm not proud of this 15-page record. It has almost 100 entries, over 200 charges, 9 convictions, over 100 dismissals. So and I appreciate the testimony of the gentleman before us because 3 of these entries are assault and battery on a police officer. And when due process played out, those cases were ultimately dismissed and or not guilty. But due process stopped right there because they're still on my Corey. I stand before you despite all of this as employee of the Coalition for Social Justice, working in the recovery field, also on the board of directors for the Greater New Bedford Tenants Association project. Another thing I want to make note is that drawing a little blank here, but so all of these, everything on here, is 100% directly related or a result of my drug addiction and mental health. So, and I've been clean and sober for a while now, but so despite what's on here, I've been able to accomplish a lot, but because of what's on here, it's prevented a lot of opportunities. So I just represent second chances and redemption. So I just appreciate you guys taking this up and listen to us. Because this, as we came up here from New Bedford and on the commuter rail, and then we took the red line from South Station to Park Street and walked up the hill, and I see my story everywhere, and people like in the grips of addiction and returning citizens and just folks that are not able to represent or advocate for themselves. And I've had a lot of help along the way. I've had a lot of help. So we just need a little bit more help. And so let's push this through if you can. Thank you so much.
Thank you both for your.
Yeah, I just want to mention one other thing. So this is not a policy change. This is just how something is done. Thanks to Brandy Fluker-Reed for filing this. And it would really open up so many opportunities. And of course, law enforcement, sheriffs, they all have that data anyway. But employers don't know how to read, of course. Adrian said they see this big list of charges. The dismissals are tiny, the charges are big. So it really prevents people from moving on and having that second chance. So thank you so much.
Thank you. Any questions from the committee? Representative.
Thank you, Mr. Chair. Thank you both so much for testifying. And Adrian, thank you for sharing your story. You don't owe us that, but we appreciate you sharing. And I know y'all know this far too well, but how we're treating substance abuse and mental health now is very differently than how we have treated it historically, particularly for Black and Brown communities, which I know you both know all too well. And so I just want to appreciate you for sharing and highlighting that this isn't a law change, but if we're really a Commonwealth about second chances in promoting justice for whatever you were convicted for, you did that time. This impacts housing and impacts employment and so many others. So thank you for sharing your story. And I look forward to working with the chair and others in the committee to try to do what we need to do to support this. So thank you again for your time.
Absolutely. Thank you.
Thank you both. I'll move on to another panel on this bill from Greater Boston Legal Services, Pauline Quirion and Ventura Dennis.
Good afternoon. My name is Pauline Quirion. I'm the director of the Core Reentry Project at Greater Boston Legal Services, and we've been specializing in sealing of criminal records for over 15 years. We have helped thousands of clients over the years, and we are here essentially to urge the committee to pass these two bills, H 1811 and H 1693, because over and over, we hear the same story from various clients. People have a right to seal their records, but sealing is underutilized in Massachusetts as it is in most parts of the country. So oftentimes, by the time we see somebody, they've lost the one affordable apartment, they've passed over for their dream job, or can't qualify for a certain occupation because of their record. What other states have done essentially is to automate the sealing process, and that happens in 12 other states, including Pennsylvania. And records are just sealed once the waiting periods are completed. We're not changing the waiting periods. It's still 7 years for a felony, it's 3 years for a misdemeanor. Sex offenses that cannot be sealed remain unsealable. If somebody has committed murder, they're probably going to have a lifetime parole. They're not going to be eligible for sealing. So we're not changing anything about the law of sealing, but what we're doing is we're making the process effective. Because currently it's underutilized. There are backlogs. I had clients who waited 8 or 9 months to seal their records last year after I mailed in a petition. And it's still a chronic problem. Petitions get lost in the mail. We've seen more errors sometimes in the processing of petitions. So this would really make a difference. And I would point out that in Massachusetts, 1 out of 5 people has a criminal record, and automated sealing is the only way on a large scale basis to seal criminal records and deal with the so many records that are out there. We always talk about our work as like shoveling sand against the tide because there are so many records. The Clean Slate Initiative estimates that there's at least 500,000 people would be eligible for sealing if we pass this law. So that's a lot of people who could be paying taxes. They could be working. Getting a job reduces recidivism. It's really a win-win for everybody if we're able to pass clean slate legislation. So I urge this committee to give a favorable report to these bills.
Good afternoon, committee members. Thank you for hearing us today. I want to specifically speak about H 1693, an act to remove collateral consequences and protect the presumption of innocence. As you have heard from others' testimony today, this bill would immediately seal offenses that ended favorably in dismissal or in another favorable outcome that was not a conviction. Currently, the court has a large workload and process that requires you to have a hearing before a judge if you want to seal a dismissal or no pros. And this is very convenient for many of the clients that we work with because of hard access to child care, transportation, mental health, and disability issues. Employers are also not well versed in how to read queries, and so this bill would also create a statement to announce the presumption of innocence applies when someone has an offense on their query and they were not convicted. The reason why this is so important and necessary is because employers, they just see any entry on a query as a bar to employment or volunteering most of the time. And this bill would also update the holdback provisions that currently exist. So as of now, our waiting periods to seal are 3 years for misdemeanors and 7 years for felony convictions. However, our holdback provisions that limit when they can see these convictions have not been updated to reflect these new waiting periods that were passed in 2018. So this bill would enable people to have a second chance and continue to access housing, training, any school opportunities that would be available to them. And it also would improve our economic workforce because they wouldn't be hindered by charges where they weren't found to be responsible. Thank you for your time.
Thank you for your testimony. Any questions on this?
Thank you both for your time, and Ventura, congratulations. Cost is always something that we in the Commonwealth are worried about, whether it's people cost or monetary cost. And y'all might have to get back to the committee on this, but if you do know off the top of your head, if not, just please send it later. Approximately how much would it cost to actually implement an automatic query situation like what's proposed in this bill? Or if you could check out other states and share those costs, that would be helpful.
Well, unfortunately, it's not like we can take the car in and get an estimate of the exact cost. In Pennsylvania, it costs $3 million to automate the process. I think in Utah, it was $1.5 million. But I'd point out that Clean Slate more or less pays for itself, because if you incarcerate people, it's 100 to 140,000 a year. So if you do the math, 50 people get jobs, they don't recidivate, they don't get in trouble, then you're saving a lot of money for the Commonwealth. Plus there's less reliance on public assistance. There's more taxes being paid. And it also addresses some of the economic needs of the Commonwealth, because there are currently worker shortages in lots of occupations and fields right now. We'll send the committee a copy of the Clean Slate Initiative policy paper on the Massachusetts case for Clean Slate from the business perspective.
And then Pauline, those figures you just stated, are those the startup costs or the actual ongoing annual cost was implemented?
Those would be for doing the automation. And like I said, it's going to vary. I mean, we're fortunate in Massachusetts and the records are really all in one place. And some places like California, the records are kept by county. So those are kind of a nightmare in terms of implementation, but the records are all in one place in Massachusetts.
Thank you.
Very good question. And I appreciate your clarification. There's nothing new in terms of legal aspects of this law. Sealing is the law. This is more of an efficiency and creating a system for already passed legislation. That system, has there been feedback from the trial court about that system? Has there been expressed concerns? Partnership, I can speak from experience with eviction sealing. We had to give her like a 9-month lead time, and that was not even for automatic. So what has been the...
Well, we actually had a meeting with the Commissioner of Probation's office, and the concerns largely expressed had to do with the automation process and just saying that obviously they didn't have the computer equipment to do Clean Slate, at the present time.
So it's been more about the technology to do it.
Yes, largely. I mean, I'm not aware of, at least in the meeting that we had, it was Senator Friedman was there, myself and some other people from the Clean Slate Coalition. And we also had a person there from Code America, who is a computer expert who has consulted with a lot of other states that have implemented, automated sealing.
Thank you.
See nothing else? Thank you both.
Thank you.
Calling now from Greater Boston Legal Services as well, Obiama Onkwanko. Did I get that right? Obi, sorry. Welcome.
Thank you, members of the committee. My name is Obioma Okonkwo, and I am responsible for the Criminalized Survivors of Domestic Violence and Trafficking Project at Greater Boston Legal Services. And I'm here to support the H1811 and H1693. And at the heart of this bill is, like my colleagues have mentioned, the presumption of innocence and the promise of redemption for those who have served their time. My clients, when they stand criminal trial, especially clients who are survivors of domestic violence and who acted in self-defense, when they stand criminal trial, they enjoy the presumption of innocence. But when they leave the courtroom, when they get a verdict of not guilty, when they get a verdict of dismissal, they do not enjoy that presumption the moment they step out of the courtroom. But then the law provides that they may apply to have their record sealed. But what the law is truly saying is that for them to be treated as innocent in their job applications, in their housing applications, they have to apply for it. So why would the burden of applying be on the people who have received the verdict of dismissal? Why would it be on them to enjoy their constitutionally guaranteed rights? Now, for those who have served their time, who have been convicted, and they're now re-entering the society, what the law provides is that they may apply to seal their records 3 or 7 years after. But what the law is truly saying is that they have not really served their time, that they need to do more work, that they have to be the ones to keep the timelines. They have to be the ones to navigate the complicated process. And then people would wonder, well, it's just an application. Why can't they do it? But the problem is that the burden of applying is not equal. For so many, they have access to lawyers, they have access to legal aid, but most people don't even know that they're eligible. They don't even know that they can deal with this system. They don't even know that they are so deep in shame and the struggles of their records that they do not know how to overcome this barrier. So I urge that you should find favorably in favor of H1811 and H1693, so that the presumption of innocence will not end in the courthouse for those who have received the verdict of a dismissal. And then for those we have promised that they can re-enter the society, that promise of redemption, it should not end at the prison gates. Thank you.
Thank you for your testimony. Questions from the panel? Oh, committee, sorry. Seeing none, thank you.
Thank you.
I'll now move to virtual testimony on the same bill. Noah Risley from Justice for Housing. Here in person. Welcome.
Good afternoon, Chair Day, Chair Edwards, and other esteemed members of the committee. Sorry to surprise you, Edwards. I'm here to tell you just a little bit about what can happen when you look past the quarry and assess the individual. So my name is Noah, as you all know, and I work at a place called Justice for Housing as a case manager. So Justice for Housing is a nonprofit focused on housing justice-involved individuals, or JIIs for short. And so one of the ways we do that is through the Stable Housing and Reintegration Program. We call it SHARP. And we work with the Boston Housing Authority. And one of the first things we did is we negotiated with the BHA to not just automatically reject someone's application for a housing voucher when they see a positive quarry result. And through that, we've been able to do some really amazing things. One of which is we've housed over 100 people with a positive quarry since 2022. And so if you think housing is bad in Boston right now, imagine trying to navigate that when you get rejected from almost every apartment you apply to. And we have another program called Hands-on Defense, where we work with institutions like leasing offices, like individual landlords, and we get them to look beyond the quarry by providing letters from other landlords someone might have had, or their boss, or their probation officer, to tell positive stories of an individual's success. And so through the SHARP program, through HOD, we have a 2% recidivism rate in SHARP, The state of Massachusetts has a 26% recidivism rate. I'll remind you, 84% of our clients who are involved with DCF have been reunited with their children. The monthly income of our last cohort that graduated increased by an average of $1,280, and 63% have reported receiving less or no state assistance versus when they started with us. And our most conservative estimate is that we have saved the state of Massachusetts over $4 million since we started in 2022. And so the people that we work with, they are members of their Glazers Union, they're faith leaders, they founded their own nonprofits, they work for the city of Boston. And this is what can happen when you give people a safe and stable home, instead of having their CORI be basically an automatic rejection. And so I encourage you to pass the clean slate laws and act with compassion so that more people can get housed, more people can get jobs, and uplift the Commonwealth's economy. Thank you so much.
Thank you for your testimony. Any questions or comments from the committee?
I do have a couple. I've heard from your organization on several occasions about housing justice, and specifically how access to housing is directly connected to a CORI, and how and so much of your work has been housing people despite that obstacle.
Mm-hmm.
So I wanted to first congratulate and thank your organization for its hard work. In terms of the work and the people that you've been representing, do you have a rough estimate on the amount of folks that you think you'd be able to house, have not been able to house because of the CORI? That's one. And then of those, how many, if this legislation existed, you think could be stably housed now?
That's a really good question, Chair Edwards. I don't, just because we already face a capacity problem with J4H, and we have to turn away hundreds of people each year, just for like funding, and we just can't work with that many people. But I estimate if we, like as a staff member, if I didn't have to work with someone and assemble mitigating factors and negotiate, we would be able to help a lot more people. And if we could get every public housing authority in Massachusetts to adopt our mitigating factors approach rather than an automatic CORI rejection, that would make things a lot easier. Because most people with the CORI, you're not working with something like maybe a past violent offense.
Right.
And so once you are like, oh, CORI automatic rejection pile, you're like, oh, this person's a past great tenant, great credit, this is fine. And so I imagine it would make it a lot easier. Let me get with my colleagues and try and get you an estimate, and I'll send that in as written testimony, because
Thank you.
that's a great question. And I wish I had a better answer, but I'm sorry.
Good. Thank you.
Any other questions from the committee? Seeing none, thank you.
Thank you.
I'll move now to David Siegel, virtually. And then we'll go to Maggie O'Donnell after that.
Thank you very much, Chair Day and Chair Edwards. I appreciate the opportunity to testify before you and clarify the importance of automating the criminal record sealing process in the Commonwealth, and just strongly support your favorably reporting H 1811 and 1693. So I'm a professor of law at New England Law Boston, and I direct the School Center for Law and Social Responsibility. And for 14 years, I've supervised the CORI initiative. This is a student-run project that assists indigent clients in sealing their criminal records. And these are free legal services advising clients about their rights and assisting them in preparing sealing and expungement petitions. And in most cases, the clients have to go into court pro se. Automation would make much of this work utterly obsolete. And I'm asking you to put me out of a job, and put my students out of this particular job, and save the Commonwealth money and grow the workforce. All of you know the value of automating things that are important to do. Many of you may have your paychecks direct deposited. If you get your gas bill or your electric bill paid automatically, you know that it's much easier and more effective to automate doing something that's important and that you need to do regularly. As much as possible, sealing and clearing of eligible records should be made automatic. This is relief that the legislatures have already specified must be provided. It shouldn't require filing anything. 19 states and the District of Columbia have done this, and it's very effective. It saves money, it better integrates people back into a free society, and it expands the workforce. In 2017, the Boston Fed estimated a quarter of the state's residents have records, and many of them just for being charged with a crime. In 2023, about 5,700 of the 1.7 million people in the state sealed their records. That is 0.3%. We can do better, but we will never do it on paper. We will never do it by having people have to fill out petitions and mail them into the Department of Probation. Sealing a record in Massachusetts requires filing a one-page legal petition that may seem trivial to those of you that are attorneys, but it's enough that many lay people who can afford to do it hire a lawyer to do it. So it's not trivial to them. I'd encourage you to simplify and speed sealing of records to grow the workforce and reintegrate returning citizens more quickly and effectively, and that will benefit all of us. Thank you very much.
Thank you, Professor Siegel, for your testimony. Questions or comments from the committee? Seeing none, thank you.
Thank you.
Move now to pardon me, Maggie O'Donnell from the Responsible Business Initiative for Justice, virtually.
Good afternoon. Thank you so much. My name is Maggie O'Donnell. I'm the Director of Policy and Advocacy at RBIJ, which stands for the Responsible Business Initiative for Justice. Thank you again for the opportunity to testify in support of H 1811 and H 1693, what I will generally refer to as Clean Slate, Massachusetts. RBIJ, we are an international nonprofit that mobilizes businesses to be a force for good. Since our founding, we have worked with hundreds of employers, from multinational corporations to entrepreneurs across the country. We advocate for practical policy reforms that expand workforce opportunities and stimulate economic growth. You've heard this before, but the impact of a criminal record on a person's ability to obtain a job just cannot be overstated. 9 in 10 employers use background checks to screen applicants, and having a record reduces your likelihood of getting a call back by nearly 50%. You're almost always at a disadvantage when you have a criminal record. Companies and employees across the country and in Massachusetts understand the impact of having your record sealed. For one, businesses can't afford to exclude great talent from the workforce. Over the last few years, I've had a lot of conversations with chambers across the Commonwealth, with businesses big and small. They still want to fill open jobs. Meanwhile, this outdated petition-based system keeps people out of those jobs. This worsens the labor shortages, reduces consumer spending, and shrinks tax revenue. Clean Slate would allow new pipelines of hardworking talent to fully participate in the economy. It would reduce turnover costs and ease labor shortages. It would also have a huge impact on the Commonwealth's economy because the U.S. loses more than $80 billion with a B in GDP each year due to the underemployment of people with records. Removing barriers reduces the need for long-term government support, thereby saving tax dollars. Clean Slate would also reduce recidivism because we all know that having a job is one of the most important factors to whether or not someone will reoffend. I'll end by reiterating that the business community stands in strong support of this legislation. You've heard from many businesses over the past year or so on this issue. JP Morgan Chase has testified in support of it, State Street has testified in support of it, and many others. At the national level, I'll also add that the U.S. Chamber of Commerce and many other multinational corporations have been outspoken in their support for efforts like Clean Slate. I've not spoken to a single business leader across Massachusetts who have been opposed to this effort, and I'm really eager for you all to hopefully pass this favorably. A criminal record really just shouldn't be a life sentence to economic hardship. I believe that everyone, regardless of their past, wants the opportunity to work, support their families, and build a good life. I think we can all agree on that. Thank you so much. I appreciate the opportunity.
Thank you for your testimony. Any questions from the committee? Seeing none, thank you. I'm going to take a pause in testimony on record sealing and turn back. I've been informed that District Attorney Quinn has joined us virtually again on H 1691, an act relative to certain offenses filed by Representative Fiola. District Attorney Quinn, welcome.
Yeah, welcome. Good afternoon, Chairman Day and Chairman Edwards. Thank you for the opportunity to address you on the House 1691. Testify in support of the amendments adding additional offenses of dangerousness statute. I think it's a common sense amendments that allow the district attorneys to file requests to detain people if the facts and circumstances warrant it. I would point out that obviously this is subject to judicial review and this is not mandatory. Just want to touch on a couple of points. The bill includes amendments related to sexual crimes against children. That's certainly a grave concern to people. I would point out that in 2019, there was a Supreme Judicial Court decision that said the aggravated rape of a child was not an offense that could be considered under the dangerousness statute. It was the issue of the use of force that could not simply be put in place because of the child's inability to consent. I think a reasonable person would say that the Commonwealth should have the ability to move to detain somebody if the facts and circumstances warranted. For example, if a 40-year-old is raping an 8 or 10-year-old, there should be that ability to detain them. Otherwise, no matter what their record is, they could be a predator, they could have a horrible criminal history and be a clear danger. The only alternative would be a high cash bail, and obviously a judge is going to be concerned about putting somebody like that out on the street. So this amendment would allow the Commonwealth and the court, if warranted, based on the facts and circumstances, to detain someone. So that's a SJC decision. With respect to another charge, manslaughter, involuntary manslaughter, there was another court decision that came from our county that said that manslaughter, because there could be two theories, you could intend it, but if you could also be convicted under a wanton and reckless theory, that prohibits that crime, again, manslaughter, from being considered under the dangerousness statute. There are many serious crimes that would warrant the opportunity for the Commonwealth to file to detain people under, again, specific circumstances. Number of firearms offenses are added under the statute. Illegal firearm offenses, certainly we all know that the number of firearms out on the street are significant, that are causing wreaking havoc and causing carnage in our communities. Clearly, there should not be limitations on those offenses with respect to the Commonwealth moving to detain people. There is just one brief comment. There's another court case, assault and battery by means of a dangerous weapon. I believe is not one of the offenses. I would just point out that too, similar to manslaughter, has been ruled to be an offense that you cannot move to detain anybody because there are two theories of the crime being committed. And again, this is from the Supreme Judicial Court. So, and that certainly is a violent offense, committing an assault with a dangerous weapon. So I don't think these are unreasonable to add these offenses. There's due process available. A court has to make a final decision, and I think they're appropriate to protect the community from certain individuals who are committing crimes in our communities.
Thank you, District Attorney Quinn, for your testimony. Any questions or comments from the committee at this time? Seeing none, thank you. Appreciate it.
Thank you for your time.
I'll go back now to H 1811, an act requiring clean slate automated record sealing by Representative Keith and Representative Vargas, and welcome in person a panel of Andrea Freeman and Brother Al Hubert. Welcome.
Good afternoon. Good afternoon, everyone. My name is Albert Hubert. I like the AK Brother Al. I'm with the Men of Color Health Awareness in Springfield, in Springfield, Mass, down there in the Basketball Hall of Fame state that we just had a crowd of great individuals who just visit the state of Massachusetts. I'm here for the Clean Slate Bill. I think the Clean Slate Bill is a very important bill and a bill that should be approved. And I think the reason why I say that because it brings emotional, how do we escape emotional incarceration? When a person has made his atonement or made his civil commitment to the state of Massachusetts or what he has done, he's still mentally incarcerated because of the Corys does not give him this opportunity to be a better person, he wants to become a better person because he has made an atonement by whatever degree that he has decided. And it could be spiritual, it could be whatever that individual takes that recovery path. But the incarceration and the emotional incarceration to these Corys is the individual doesn't have an opportunity to be successful. You heard a lot of testimonies before me, so there's no need for me to go over that again. But the most important thing about this bill will release that individual from the emotional incarceration to be a productive member of society, making good, healthy choices and having a positive future, being a protector and a provider for his family, for economical development. It will help communities across the Commonwealth. We know that there are 12 other states who have done this or in the process, and we know that the state of Massachusetts has always been a game changer. This state has always been a game changer. If you look over the history, and I don't need to go over it, but it always has some type of part of how the society has been shaped in the Commonwealth. So we just want this board, this chair and this committee to really look at it and realize that we need to help each other. It's not just, it's a very important bill, and we've been on it for a while, but we know that dealing with men in the greater Springfield who has come back from incarceration and knowing that this challenge, this bill, this Corey has hindered them. And so the recidivism is there. They go back to doing what they usually do. Or they done got a job and then 6 months later, you have a Corey, so we have to let you go. So now we got drug dealers, we got people who are under substance abuse are back on the streets doing the same repeated insanity things after they made their commitment to make a change. I understand this because I had to fight my own mental and emotional pain and trauma that I have experienced in my lifetime. But I made a dedication to show up on a consistent and determination to be the best person I can be and not repeat the insanity that I have been redeemed from. But we know if we can give people, the state of Massachusetts will give individuals an opportunity to at least get a job and to be better men and to be better women in their community. This will too be a revolutionary movement that the state of Massachusetts had a hand in it to make things happen. And I just know that we all know someone or a relative that has a Corey. Please do not allow this criminal offender record information hinder a person who has really turned their life around. Because we know a Corey is a chain and ball you do not see until you fill out an Corey and it comes back. But I appreciate this opportunity to be with my partner, Andrea Freeman, and with the Boston crowd. Thank you for allowing me to share.
Thank you. Thank you. I don't want to have to follow that, but I have to follow. I'm Andrea Freeman of the Public Health Institute of Western Mass, and so many folks have already said what is important to say. And I just want to point out that we're not asking the law changed. We're not asking to change who's eligible for record sealing. We're not asking you to change who has access to a sealed Corey. We're simply asking you to greatly simplify the process, eliminate the flaming hoops. Thank you.
Thank you both for your testimony. Any questions from the committee? See none at this time. Thank you both.
Thank you, sir.
Next panel will be from Mass Cultivated, Ryan Dominguez and Shay Rainey. Okay. Welcome.
Chair Day, Chair Edwards, members of the Joint Committee. My name is Ryan Dominguez. I'm the Executive Director and original founder of Mass Cultivate Ed. Mass Cultivate Ed is a nonprofit organization I started in 2020, whose mission is to create expungement, education, and employment opportunities for those impacted by the war on drugs. So thank you for the opportunity to testify in support of H1811 and H1693, the Clean Slate bills. Mass Cultivated has been providing opportunities for individuals and communities impacted by the failed war on drugs to enter into the cannabis industry. However, before giving them these opportunities, our team members have done the hard work of helping to undo the harms of former policies that furthered mass incarceration through policing cannabis. We have hosted over 30 quarry sealing and expungement events across the Commonwealth and have helped over 300 people get one-on-one legal help to understand the complexities of sealing one's record. This process is onerous, and many of our most vulnerable populations have barriers to education, housing, and employment based solely on the fact that our processes are so complex. Thousands of residents of the Commonwealth are living silently with criminal records. The effects of those criminal records can last a lifetime, and communities of color are still disproportionately impacted by our criminal legal system. And we have seen that Governor Healy had pardoned many of the people with simple cannabis possession charges, but many of the folks that I've spoken to have not been able to access those same benefits, just like quarry sealing and expungement. And so the war on drugs has created a system where cannabis was used as a tool to unfairly police Black and brown neighborhoods. It was used to search people, cars, homes, and place trumped up charges on people's records that still have long-lasting impacts on people's lives today. We've had many stories from program participants from our program that the road to clear a record was not easy. We started our program in the middle of 2020 during COVID, and so you can only imagine how hard it was to get paper files sent back and forth between people who were trying to isolate in the legal aid organizations whose offices were primarily closed. Yet we experienced all of this and still are keeping the same system in place. Can you just imagine the frustration of reliving the trauma of a past mistake and then trying to clear up your record, and then it gets lost in the mail and you're not actually able to clear your record? You would want to quit right there, and from my experience, many have. So instead of having someone who is excelling and realizing their full potential, you have countless others who are left hopeless and feeling the system just does not work for them. So thank you again for the opportunity to testify, and we hope that you will pass this forward favorably out in the committee.
Thank you for your testimony. Appreciate it. Any questions from the committee? See none? Move to virtual testimony in this bill. Rasan Hall from the Urban League of Eastern Massachusetts.
Morning, or sorry, yep, can you hear me? Sorry. Good afternoon, Chair Day, Chair Edwards, and members of the committee. Thank you for the opportunity to testify. My name is Rasan Hall. I'm the President and CEO of the Urban League of Eastern Massachusetts. I'm a member of the Clean Slate Massachusetts Steering Committee, and I speak today in strong support of Bills H1811 and H1693, which would implement a clean slate policy by automating the sealing of criminal records in Massachusetts. So you've already heard from many amazing speakers, so I'll merely add my voice to and that of the Urban League to the great cloud of witnesses who have testified in support of these bills. And in 2018, the Massachusetts legislature passed a historic Criminal Justice Reform Act, and that law made important strides, reducing mandatory minimums, improving parole access, and making some records sealable, but left unfinished this business. The promise that reform will remain incomplete until the sealing process is automated. At the Urban League, we provide job training, career readiness, and economic mobility services across Eastern Massachusetts, but far too many of our clients, particularly those who are Black and Latinx, remain locked out of opportunities due to old criminal records. I had previously testified and shared written testimony about the Harvard Law School's report on racial disparities within the criminal legal system, that Black residents are 6.5 times more likely to be incarcerated than white residents, and that these barriers continue to carry long-term outcomes for them. Or a reference to Harvard sociologist Eva Pager's seminal study, The Mark of a Criminal Record, that found having a criminal record cuts job callbacks by 50%. And a Black man without a criminal record fares worse than a white man with one. So just imagine how that is exacerbated for Black men who have criminal records. So Clean Slate is not just about justice, it's about jobs. Automated record sealing has been shown to increase wages by about 25% and improve employment rates. And that's not just good for families and those individuals, but it's good for our economy. This is a racial justice issue, a workforce issue, and a chance for the Commonwealth to finish what we started in 2018. And so we urge you to report these bills favorably out of committee and give our residents a real second chance. So thank you again for the opportunity to testify.
Thank you for your testimony. Any questions from the committee? See none, thank you. Move now to Alan Epstein from the Greater Boston Interfaith Organization.
Thank you, Chair Edwards, Chair Day, and the members of the committee for the chance to speak to you today in support of two clean slate bills, House 1811 and 1693. My name is Alan Epstein. I serve on the board of the Greater Boston Interfaith Organization. For over 25 years, GBIO has worked for the public good by training and organizing people across religious, racial, ethnic, class, and neighborhood lines. Our 52 mosques, synagogues, churches, labor unions, and community organizations represent tens of thousands of individuals across the Commonwealth. The clean slate bills before this committee represent an effort to provide a path to normalization for formerly incarcerated individuals. Massachusetts expects them to reintegrate into society as productive members, but without automatic record sealing, we continue to hold up significant barriers. The alternatives are homelessness, unemployment, and reincarceration. The safety of our neighborhoods for all of us depends on returning citizens securing a job and housing, as well as other services. Automatic record sealing removes a significant impediment toward these opportunities. GBIO takes a moral stand for returning citizens and for all citizens. Now is the time for Massachusetts to join the 12 other states that have passed clean slate legislation since 2018 in rethinking how justice and safety are supposed to work. Democratic and Republican-led legislatures across the nation are moving to create these conditions. It is time for Massachusetts to do the same. We urge you to vote these bills out of committee and ultimately to passage for the benefit of all of us. Thank you. I'll submit written testimony as well as that of a justice-involved colleague who was not able to be here today.
Thank you, Mr. Epstein. Any questions from the committee? Seeing none at this time, thank you. Move now also virtually from the Clean Slate Initiative, Katie Svoboda Kindle.
Hello. I'm not sure if I'm on camera yet.
We've got you.
Excellent. Sorry about that. Good afternoon, Chair Day, Chair Edwards, and esteemed members of the committee. My name is Katie Svoboda Kindle. I am the Implementation Director at the Clean Slate Initiative, which is a national nonprofit whose mission is to work alongside states to enact and implement laws that seal records using automated and government-initiated processes. We are strongly in support of House 1811, which will impact almost 500,000 Massachusetts constituents, bolstering public safety, stimulating economic growth, and ensuring equitable access to record relief. Over 1.1 million adults in Massachusetts have an arrest or conviction record. Despite completing their sentence and remaining crime-free, these constituents are often denied a fair chance at jobs, housing, and education due to the prevalence of background checks. The burden of records disproportionately impacts people of color, with Black and Latino adults being 3 times more likely to have a record than white adults in Massachusetts. Sealing opens up opportunities because it keeps sealed records off of background checks. Federal law requires background check companies to use reasonable procedures to get up-to-date information and remove sealed records. Enforcement of the law has been effective, making background checks more accurate. In fact, a recent study of automatic record sealing laws in 5 states found that on average, 98% of the commercial background checks removed sealed records. Clean slate policies transform lives and strengthen communities. Research indicates that an individual's wages can increase by up to 22% in the first year following record sealing, and that people who have stable jobs and pay a livable wage are much less likely to commit crime. Unfortunately, fewer than 10% of people eligible for relief under current petition-based record sealing policies actually go through the petition process. Clean slate laws address this gap by making record sealing accessible to everyone who is eligible. By leveraging technology, clean slate laws accomplish otherwise impossible levels of impact. In Pennsylvania and Michigan alone, clean slate laws have sealed the records of over 2.5 million people. We estimate that House 1811 will seal records for almost 500,000 adults in Massachusetts, greatly surpassing the impact of Massachusetts' current sealing laws. 12 states in the District of Columbia have already enacted clean slate laws, and alongside our partners, the Clean Slate Initiative has helped design and implement many states' new processes. We stand ready to help Massachusetts implement an efficient process that leverages existing data systems and capabilities. House 1811 is designed to be technically feasible, meaning that the eligibility determination and sealing process can be largely automated using technological tools, modernizing and streamlining the current manual processes used to seal records. And in summary, the Clean Slate Initiative urges the Joint Committee on the Judiciary to support House 1811, which is a smart, feasible policy with a huge potential for impact. Thank you.
Thank you for your testimony. Any questions from the committee? Seeing none? Thank you. Move now to Esther Arias from Justice for Housing, virtual. Not present at this time. Jay Villar from the Fountain Fund. Welcome.
Thank you so much. Good afternoon, everyone. My name is Jay Villar. I am the Boston site director for an organization called the Fountain Fund. The Fountain Fund is also on the Clean Slate Steering Committee. And we work specifically with individuals who have been formerly incarcerated to give them access to capitals, specifically in the area of microloans, so that they could economically enhance their lives. In order to receive a loan from the Fountain Fund, you need to be working for at least 3 months so that you can qualify for the loan program. Where we come in as far as like the Clean Slate Initiative and supporting automatic sealing is I receive a lot of calls from our respective client partners who are looking for opportunities to get their license back, looking to access transportation, looking for housing, all of the things that we need in order to move forward in our lives that many of us can simply swipe a credit card for. And some of the individuals call me and says, well, Jay, you know, I've been working for the last 2 weeks, and then they pulled my query, and then I was let go. And that has happened a number of different times. So as we all know, having access to income as relates to paying a livable wage job is what is going to create opportunities for all of us to succeed. But if what's getting in the way is a query that had been automatically sealed without having to know about all of the paperwork that goes into doing so, creates significant barriers for somebody to actually move forward with their life. So I encourage the committee to consider passing each 1811 and 1693 out of committee to pass Clean Slate into law. So thank you so much for your time, and I'll yield the rest of my time.
Thank you, Mr. Black. Any questions from the committee at this time? Seeing none? Thank you.
Thank you.
Move now to Elhaj El Shabazz from the Western Mass Public Health Institute. So you're on mute. If you could unmute yourself, we can get you.
My apologies.
There you go.
My name is Elhaj El Shabazz. I'm speaking on behalf of the Clean Slate Initiative. I want to start off by saying that for me, the initiative is very transformative, as well as a public health initiative. And what do I mean when I say that? Because as an individual who was formerly incarcerated, when I had successfully reintegrated back into society, not only did I have to overcome the mental, emotional, and physical barriers that come with reintegrating back into society from a long period of time, and just learning how to make that adjustment and do things that I've never done prior to. Having the additional barriers of a Corey, which interfered with my ability to successfully integrate in a smooth way. It didn't ultimately stop me from transforming my life. However, it affected so many different areas of my life. And I understand as an individual that was affected by it, if it really wasn't for the development of my own self-worth when I was incarcerated, I would have came out here and it became a statistic ultimately, because there's a lot of barriers, and individuals spoke about the emotional turmoil and mental turmoil that individuals go through from being faced with the barriers of not being able to get a job or not being able to get an adequate job, right? Because that means a lot. You may be able to get a job, but not being able to get an adequate job to transform your life. That's important. And not being able to get housing. I was the individual that, had it not been for an organization putting their name on the line, I would not have obtained housing. And one of the things that an automated sealing process would do, like the individual, one of the individuals stated, it would ultimately relieve a lot of people from a job. What do I mean by that? Meaning it would relieve it would relieve the state from giving out a lot of money to individuals that do what we're already asking the state to do naturally. As far as the public health initiative that I was speaking about, I definitely considered it became inklings of thoughts when I couldn't get a job, when I was suffering from striving to find housing or shelter. Just through the many different barriers that I faced from having a criminal background, that in and of itself, had I, like I stated, not built my own character, I would have immediately went back to prison. And there's a lot of individuals that fall in that box, unfortunately, because they do come out here and start to be successful and reintegrating. However, the barriers that stop them from having a smooth transition. So for me, I would encourage, the committee to really consider the decision that y'all making, because this definitely does affect individuals on a higher level. And just as an individual who was formerly incarcerated, gratefully since then, because I've been out now, I've been home now 9 years, and through that process, and I've had my record sealed. And because I've had my record sealed, I've been able to change my lot in life. You know what I'm saying? So I encourage y'all to please really weigh this decision with a heavy heart. And that's my testimony. I appreciate it. Thank you.
Thank you for your testimony, Mr. El-Shabazz. Any questions from the committee? Seeing none at this time, thank you.
Thank you.
I'll move now to Edwin Perez.
Yes.
Go right ahead, sir.
Hi, my name is Edwin Perez, 41 years old. Dealing with the incident that happened in 2007, it still affects me from getting a job, my living situation, not only with like work ethic and trying to just survive for my family, but also missing times with my kids when they were younger, not able to do field trips, not able to volunteer at the school due to having a sealed record or a criminal record and stuff like that. I tried, since 2007, I tried going to like local courthouses or getting advice through other people without having to hire a lawyer, because hiring a lawyer is cost of living, will take money out of my pocket from my kids living, from eating, or to our living situation. So it's just kind of hard when they say, oh, go hire a lawyer, they'll figure it out for you. It's just very hard for us to get to that situation. I had good jobs in the past where I thought everything was going great. Then once the Corey comes back, they have to relieve me due to the Corey check. It's just not fair that we're able to fulfill the job able to show ourselves to the work ethic and stuff like that. But once the Corey comes back, it's like we have all these bubbles above our heads that's holding us back from living a better life, trying to do better in the community. And it's just more easier for people to commit crimes than to go out there, get a job and do the right thing. And it just keeps lacking and keeps lacking. And we're just trying to break the cycle, not just for myself, for other people out there. Just we want to be able to work and have a fair trial in life and not be judged by our past or something hanging over our head. So I appreciate your time for hearing my voice and trying to move this forward for us. We really do appreciate it. Thank you.
Thank you for your testimony, Mr. President. Questions from the committee? Seeing none, thank you again.
Thank you so much. Appreciate you guys.
I move now to Isabel Warner, Mass Law Reform Institute.
Hello. I am on camera. Good afternoon, Chair Edwards, Chair Day, members of the committee. My name is Isabel Warner, and I am the Health Justice Advocate at Massachusetts Law Reform. MLRI is the statewide poverty law and legal services support center. In this role, I focus on the challenges faced by people returning home from incarceration, and I've often seen how criminal records create barriers that prevent people from rebuilding their lives in Massachusetts. I'm here today in strong support of the Clean Slate legislation, House Bill 1811 and House Bill 1693. Right now, more than 672,000 people in the Commonwealth are eligible to seal their criminal records, yet fewer than 10% are able to actually do so. This is in large part because the current process relies on heavy paperwork, formal petitions, and procedures that are nearly impossible to navigate without legal help. And this burden isn't shared equally. Black and Latino residents are overrepresented among those with records due to well-documented disparities in our policing, charging, and sentencing at every stage of the criminal legal system. That means the barrier of a record falls hardest on communities that are already over-policed and under-resourced. And the harm doesn't really end when the sentence ends. A criminal record, as we've heard today, continues to follow people for years, locking them out of jobs, housing, and economic opportunity long after they've returned home. Clean Slate fixes this. House Bill 1811 would ensure that once the waiting period is complete, sealing happens automatically, no extra petitions, no red tape. House Bill 1693 would ensure that non-convictions are sealed promptly so people aren't punished for charges that never should have followed them in the first place. As a legal advocate, I can tell you these reforms are both practical and overdue. They streamline a process that the law already follows, and they ensure fairness, consistency, and equity. Most importantly, they give people a real chance to rebuild their lives and fully participate in our communities. For these reasons, I respectfully urge the committee to pass these two bills. Thank you for your time.
Thank you for your testimony, Ms. Warner. Any questions from the committee? Seeing none, thank you. All right, move on now to consideration and hearing on H 2050, an act removing barriers, the expungement of records filed by Representative Williams, and a virtual panel from Justice for Housing, Jamila Smith and Lamar Bohr. Not present. Okay, the committee will now move to testimony in consideration of H 1743, S 1230, an act establishing medical civil rights, filed by Representative Hendricks and Senator O'Connor. And welcoming up first, Jeffrey Tegnell. Jeffrey Tegnell. Welcome.
Thank you, Chair Day and Chair Edwards. I'm here today to speak in support of the Medical Civil Rights Act, which is H 1743, and the act to study the delivery of medical care to persons held in custody, which is H 1745. My name's Jeff Tegnell, and I'm a retired Brookline educator who spent 42 years teaching middle and high school students about U.S. government, the Constitution, and the criminal justice system, among other civics topics. I became aware of the efforts to persuade Massachusetts legislature to pass the Medical Civil Rights Act in 2021. And in 2023, after the bill was reintroduced, I met with my state representative, Paul McMurtry, and attended presentations at the Statehouse and elsewhere by relatives of impacted individuals who died or suffered poor medical outcomes because of delays in the provision of emergency medical care during police interactions in jail, prison, and other correctional facilities. For instance, a Massachusetts wife recounted how her husband had become disabled after having been apprehended and jailed as a violator of a DUI when he was actually suffering a stroke. Family member testimony has been both compelling and heart-wrenching. What all these deaths have in common is the absence of clear directive that law enforcement officers who encounter people experiencing psychological and medical emergencies must provide them with emergency medical care that they request or obviously need. And passing Medical Civil Rights Act will prevent those needless deaths, injuries, disabilities, and poor medical outcomes. In addition, I would like to say that I was doubly shocked to learn that despite numerous custodial deaths, data collection is skimpy at best. Today, the Globe reported that 300 people have died in custody since this bill was first proposed to Massachusetts in 2019. WBR reported in 2020 that a third of custodial deaths studied in Massachusetts involved inadequate medical care of folks in custody. So the Deaths in Custody Reporting Act limits data collection to counting of deaths in custody with scanned information about the factual circumstances of each death. What is not recorded are the medical needs of the person held in custody, the care they asked for, and whether they received it or didn't receive it. So I want to thank you for your attention to this testimony. I think that both of these bills are examples of humane, science-based, and physically responsive laws, which the Commonwealth has in the past prioritized. So thank you for your attention.
Thank you for your testimony. Questions from the committee? Mr. Tegno, just to clarify, that Globe story was talking about nationwide deaths, not to minimize, but not Massachusetts only for the 300.
Massachusetts. Yeah.
Nationwide.
Yeah.
Yep. Yes, sir. I'll call up Barbara Donnellan. Welcome.
Good afternoon, chairs and members of the committee. My name is Barbara Donnellan, and I'm here to testify in strong support for H 1743 and S 1230, the Medical Civil Rights Act. Right now in Massachusetts, if you have a medical emergency while interacting with law enforcement, there is no guaranteed right that medical help will be called. That means if you have a heart attack during a traffic stop or your child goes into diabetic shock during an arrest, there is no legal assurance that emergency medical care will come. People in our state have already died because that care was delayed. This bill would fix that. It establishes a clear right to immediate medical attention whenever someone in law enforcement custody, or even just in contact with police, says or shows that they're in medical crisis. Officers would have to call emergency services and let medical professionals do their job once the scene is safe. In other words, this bill guarantees access to life-saving care in moments when every second matters, something most people assume already exists, but doesn't. This isn't radical. Connecticut passed the same law in 2023, and their fiscal office found it cost nothing to implement. In fact, by preventing needless deaths and expensive lawsuits, it's expected to save taxpayers billions. This bill is not about expanding liability, it's about preventing tragedy and upholding the most basic human dignity, the right to medical care when your life is in danger. And to be clear, this doesn't mean asking officers to become medical experts. The standard is simple. If someone says they're in crisis or it's obvious that they are, you call for help. That's common sense. It protects the person in distress and it protects the officer. Members of the committee, we can't leave this gap in the law any longer. Every year that this bill is delayed, lives are put at risk. No one in Massachusetts should die in police custody or in any law enforcement encounter because medical care came too late. I urge you to move this bill forward and make Massachusetts a leader in guaranteeing the most basic civil right of all, the right to life-saving care. Thank you.
Thank you for your testimony, Ms. Danella. Any questions from the committee? Seeing none, thank you. And next we'll call up Kenneth Riley.
Chairman Edwards, thank you. Anybody else? I sit here as an impact father. I was here a year ago in front of this board talking about what it means to lose a loved one when it comes to an intervention with mental health, the police. This happened in Lexington. As of now, it's sort of a situation for me is this, my son was under the care of the Elliott, and it's sort of been a one-sided issue. And the thing with me is I don't think the town of Lexington wanted that outcome. So we don't want these outcomes. So I'm hoping this committee will take a hard look at this bill and say, how can it impact everyone with mental health issues when they're in interaction with police? If Connecticut can do it, we can do it. My daughter has an op-ed in the paper today. As far as the details and things, I would hope everyone would just take the time to read it. I do think, for me, it was the bill, when I first heard that Senator Miranda had it, and it was written by people from Harvard, and it was also sponsored or written by Judge Brown, an appellate court judge appointed by a retired appellate court judge appointed by Governor Dukakis, and it was a black man, and Senator Miranda was a representative for the city, the inner city. I was all in. I said, this is what we need, because it's only going to get worse. The situation is going to get worse. These interactions I'm not anti-police or anti any of that. I do think we'll all work it out and we can debate it on the floor. And maybe there's other agendas that I don't know about. I'm not supposed to know about. I'm not political. But I know in Connecticut, all the political groups work together. And I also think the police and the boards were on board. So the sheriffs, the police, obviously, they have to support it. So this has to come from a collective group. And I'm hoping it's the bill that everybody decides that we can all work on it as one big group. This doesn't have to get political. So that's my hope. So that's why I'm here. Thank you.
Thank you, Mr. Riley, for your testimony and sharing it again. Any questions from the committee at this time? Seeing none, thank you.
Thank you.
And next we'll call up Diane Veitch. Veitch, sorry. Welcome.
Thank you, chairs and committee, for listening to my words today. My name is Diane Veitch. I'm a resident of Bellingham, Massachusetts, and an average citizen. I'm speaking to you today because I had a conversation with my sister-in-law, Mary Kathleen Veitch, and she is a cardiac registered nurse with 30-plus years of experience working with pre- and post-op heart transplant patients. And she shared an experience that she had. This is what she said. I took care of this young woman pre- and post-heart transplant. She was a beautiful 20-something-year-old Black woman from the Atlanta area. She had a very abusive husband and who got angry with her and started pounding her chest post-transplant. In fear for her life, she shot and killed her husband. As is typical of spousal abuse situations, she was tried and found guilty of murder and sentenced to prison for decades. Once she was in prison, she did not receive her anti-rejection medications, or for that matter, any of the medications on a regular basis, or often not at all. Needless to say, with no medications, no concern from the prison system, and with her being a woman, and a Black woman at that, she died. So this is what Kathy said. I would say it is not simply important that this bill passes, it's essential. I agree with her. And that there is any hesitation with passing this bill simply reflects the moral failure of the legislature. Thank you.
Thank you for your testimony. Questions? Seeing none? Thank you. Next up, Peter Murphy.
Good afternoon, everyone. Honorable members of the Judiciary Committee, Joint Committee, thank you for the time today to speak. I come to you as a retired police sergeant after 3 decades. As a sergeant in the department that I worked in, I was also the station commander and watch commander. So basically, all responsibility and decisions landed at my feet. I was basically the active chief for weekends, nights, in urgent and immediate emergency situations. I did not have a luxury to call a district attorney or a doctor. Things were happening quickly, and we only had 4 officers on the street. I respectfully come before you today in support of the Bill S-1230 and H-Bill 1743. I sit here, as I said, with over 3 decades of law enforcement training and experience, the last 22 years of which I served the rank of sergeant, officer in charge, and station commander, as I've mentioned. During my career as a police officer, I personally responded to several situations where firearms were possessed by individuals experiencing a medical and/or mental crisis. Tragically, not all those situations ended favorably. One particular incident took place during a prisoner transport to a local hospital by a lone officer. Again, staffing is always an issue, money is always the issue, and it's got to have a different mindset going forward. During the triage of this giant of an individual in custody at the hospital, the officer's revolver, a .357 Magnum, was wrestled from him, and a shot was fired that went through a triage door. Nobody was killed. Miraculously, no serious injuries resulted in that incident. However, the officer sustained hearing loss, permanent, as a result of the blast that occurred right next to his head. Sadly, I also was on a department that sustained or endured a suicide in a cell block by hanging. I submit that there is no substitute for continued and extensive in-service behavioral crisis training of law enforcement officers, because they will certainly often be dealing with subjects in medical emergencies, behavioral, mental in nature. The mere communication by a subject in custody of the onset of an emergency medical condition of any nature must necessitate an immediate emergency medical service be called in. In closing, professional intervention must be mandated with this bill and at the first sign of any medical or mental instability. No cost factor in staffing of personnel should ever be a determining factor in the duty to care. Any chief, colonel, or sheriff not supporting this bill, I can't understand why they wouldn't. I believe your committee passed the bill on a canine canine dog care bill, and we have Justin Root, we have a Haverhill incident and a Brookline death in a cell recently. Thank you. Respectfully submitted.
Thank you, Sergeant Murphy. If you've got written testimony, we'll welcome that as well. I didn't know if you were going to submit that, but thank you for your testimony.
I could submit it or I could send it. You tell me what you'd like.
Whatever's easier for you.
Okay.
Any questions from the committee? Okay. Seeing none.
Let's see if I can. Thank you folks very much.
Thank you.
Take care.
And now call Lenore Tululi, Medical Civil Rights Initiative. Welcome.
Today, I'm testifying in support of both the Medical Civil Rights Act and the Act to study the delivery of emergency medical care to persons in custody. And I'm one of the bill authors and one of the founders of the Medical Civil Rights Initiative. So thank you for taking the time today. So I want to start off, for years, lawmakers in Massachusetts have said we don't need these bills. However, in 2024, the U.S. Department of Justice reported that 48% of custodial deaths involved insufficient emergency medical responses. In other words, nearly a half were preventable with prompt access to emergency medical care. In 2019, our initiative that drafted the Medical Civil Rights Act to establish a right to emergency medical care during law enforcement interactions. There's a provision for co-response that's added this year. The other bill, S-1232, is to establish the first data collection in the nation to study the delivery of medical care to persons in custody, with a specific focus on the delivery of emergency medical care. I just want to point out that currently in all U.S. jurisdictions, such data cannot be collected and studied. So S-1232 would change that fact, and Connecticut is the first state in the union to enact the Medical Civil Rights Act. Meanwhile, in states like Massachusetts, people continue to die, many while imploring for access to medical care while they die. So these facts should be enough to move these bills, especially as the situation is far worse in Massachusetts than other states, according to the data. The mortality rates, for example, in the prisons in Massachusetts have been consistently higher than the national average, so high, in fact, that they're triple Connecticut in the last year studied by the Department of Justice, and the equivalent to Arkansas. Nonetheless, there's been continued opposition to the bill, which are really not on the merits. Lawmakers have claimed that increasing police accountability and litigation will stop avoidable deaths. However, the available data suggest otherwise. In 2021, the year after the Police Accountability Commission was established in Massachusetts, police-involved deaths tripled in the state. In the states with the highest payouts for wrongful deaths, the deaths continue at the same pace. And in Connecticut, after the Medical Civil Rights Act was enacted, police-involved deaths have dropped by nearly 2/3 in 2 years. So I think that's an important fact. Based on extensive kind of disinformation about the existing data and deaths in custody, one might say these rights already exist or they won't make a difference. Connecticut suggests strongly otherwise. People said the same thing about the Miranda advisement for decades. Many lawmakers opposed it, and we would now consider it to be probably one of the most important protections for people in custody. I just want to say the Commonwealth should honestly stay laser focused on preventing the avoidable deaths, not simply looking for remedies after they occur. Some lawmakers will say that people will fake medical emergencies. However, there was a safety valve drafted in Connecticut around the affirmative right. Just want to note that Connecticut reports no malingering on the bill. And in fact, there was no uptick in ambulances. It simply compressed the time that officers took to summon EMS. So it gave medics more of a chance to save someone's life. So aside from that, on the data, I just want to report that most of the deaths, nearly half of them, according to the Department of Justice, occur within the first week that people are held in jails. So people come into the jails medically unstable. If they got medical care in police custody, you prevent many of your jail deaths as well. Any questions on that? I'd like to submit FBI assault data in this state, which shows that also that due to failures in providing care to people and loss of trust in officers, nearly 80% of assaults now occur for the entire Northeast in Massachusetts.
Yeah, thank you. Would welcome any written submission you'd like to make to the committee. Appreciate your testimony. Any questions from the commission?
Any questions?
Seeing none, thank you. Also welcome up Deborah Louie.
Good afternoon, Chairs Day and Edwards, honorable members of the committee. I'm Deborah DeLuey, a founding member of the Civil Rights Initiative with my late husband, Robert, and our daughter, Leonora, who now serves as the executive director. I'm here to support H 17 43, the Medical Civil Rights Act, and H 1745. I assume you don't want the Senate numbers as well? Okay.
We've got, go right ahead.
The act to study the delivery of care. 10 years ago, a young man, Freddie Gray, was arrested in Baltimore and suffered a severe neck injury during transport. His repeated pleas for medical help fell that day on deaf ears, and Freddie Gray died. That event, the disregard for his calls for help, were deeply unsettling to all of us. My husband asked, where were the medics? My husband, whose 60-year career in medicine was dedicated to patient care, and he performed that service to people he cared for superbly. His training knew that immediate care was needed for Freddie Gray, and when none was summoned and Freddie Gray died, Leonora and Bob began to look into this. What happened? Why wasn't someone called? And it was their research, particularly that done by our daughter, that found that the law does not provide a person in custody or detained in a pre-arrest context with the affirmative right to request and be provided medical care. It was after that we drafted the Medical Civil Rights Act to address this gap. And since then, it has been submitted in Massachusetts over several legislatures. We're here again. We believe that this new law and the accompanying bill to study the delivery of care to persons in custody will save lives and provide a far better understanding than we have today of the mental and medical needs and health burdens of those in custody, many of whom have correctable issues that, if addressed along the way, would not lead to incapacitating big problems like blindness or amputation, as happens often with people with diabetes. Some advocacy groups and others have contended that the protections of the Constitution should suffice. We respectfully disagree after our research and point to the following important distinctions between the Medical Civil Rights Act and relative constitutional protections. First, the Constitution does not establish an individual's right to request and be provided access to medical care. The Constitution provisions do not guarantee the immediate provision of medical care, nor do they assure that that care is provided by a medical professional. And finally, as was the case with Freddie Gray, the constitutional protections do not apply in the pre-arrest context or earlier law enforcement encounters such as traffic stops. We made our home in Massachusetts and lived here for some 60 years. I would like this state to be one of the first to enact these bills, which will save many lives, as my husband said. Thank you all.
Thank you for your testimony. Any questions from the committee? Seeing none, thank you very much. Next, we'll call Rachel Wallace. Rachel Wallace. Jennifer Root Bannon, from Impacted Families.
Good afternoon, members of the committee. I'm here because I'm in support of H 1743, an act establishing medical civil rights. My name is Jennifer, and I'm here on behalf of my brother Justin Root, who was killed by police while in a mental health crisis. 2 years ago, I stood before you and I urged you to pass the Medical Civil Rights Act. And now here I am again. In February 2022, 2 years after my brother was killed, the legislators passed Nero's Law to guarantee emergency care for police dogs. Yet for over 5 years, the legislators have not passed the Medical Civil Rights Act to ensure that these same protections are for human beings as well. This is not only unconscionable, it is a moral failure to the highest order. Justin was 41 years old when 6 law enforcement officers shot him more than 30 times in Brookline on February 7, 2020. He was lying on the ground. He was covered in blood. He was incapacitated with nothing in his hands, and he was unarmed. He lived with schizoid affective disorder, which caused manic episodes and delusions and paranoia. Like so many people with severe mental illness, he had agnosia, meaning he couldn't perceive that he had an illness. This left him vulnerable to danger, and too often that danger comes when medical emergencies are met with police force instead of emergency medical care. The initial incident that led to this egregious death took place only steps from Mass Mental Health, right next to one of the busiest Boston hospitals. He encountered a hospital security guard who later described him as nonsensical, paranoid, delusional, clearly in crisis. Justin never threatened him. He never brandished his large, clear plastic paintball marker. This interaction ended with a handshake, but no medical help was called. My brother was at a hospital and he needed to be hospitalized, and instead, he ended up, in his final moments, having over 50 bullet holes in his body in Brookline. Had this act been in law, EMS would have been called first. My brother's life could have been saved because his death was preventable. And Justin's story is not the only isolated tragedy, because most recently there was a woman in Brookline who was found unconscious in a police holding cell. When EMS finally arrived, she had only the faintest pulse, and they tried to revive her, but it was too late. Investigators are treating her death as a homicide, and she needed timely medical attention, not neglect in a cell. Her death was preventable. In Haverhill, a 43-year-old man died after 7 officers pinned him down, face down, outside of a restaurant. Witnesses heard him cry for help, saying he could not breathe before he became unresponsive. This is what we're talking about. I'm just asking you to not let another family endure what mine and many others have endured. Do not wait until one of your own loved ones is denied the medical care when they're so clearly in need of it. Do not fail us again. Pass this bill favorably. The question before you is simple. Will you save lives, or will you allow preventable deaths to continue? I also want to say that I'm in support of S1232, an act to study the delivery of medical care to persons held in custody. I also ask you to not pass H1992. That's where officers would have the chance to review their body-worn camera footage before an official statement. Absolutely not. I won't go down that road, but that is, there's already something on the books. It does not need to be changed, and I hope that you keep it that way. Thank you.
Thank you for your testimony. Any questions from the committee? See none, thank you.
Okay.
Next, we'll call up Valerie Copeland. Welcome.
Thank you. Good afternoon, Chair Day, Chair Edwards, esteemed honorable committee members. My name is Valerie Copeland. I'm a resident of the Mattapan neighborhood of Boston. Lived here all my life. I'm testifying as an impacted person, speaking in support of the Medical Civil Rights Act. And I'm speaking on behalf of my husband, who is unable to speak for himself due to the events of April 19th, 2019, in which he suffered an intracranial hemorrhagic stroke. He has lost all memory of the incident, so he has lost about 6 to 8 weeks of time in his memory. His name is Al Copeland, and he was driving home one night after going out to help a friend who is struggling from substance abuse disorder. And he left the night before Easter to go out to see if he could get him help. On his way back, he wasn't feeling well, and he was driving up Mass Ave, felt sick, pulled his car out of the main roadway, parked in a bicycle lane, put his hazards on, and passed out. He sat in his car for a couple of hours before his vehicle drew the attention of the Boston Police Department. They pulled up behind his vehicle, pulled the little siren up, boop, boop, tried to get him to move along, but he was incapable of responding. They got out of their car, went to the driver's side window, proceeded to bang on the window, but of course he was unable to respond. Eventually, they called for backup, and he was then surrounded by 5 police cars, a police sergeant, and they went up to his window again. By God's grace, he was able to open the window that time because I'm afraid they may have broken it. They asked him how old he was. He said he was 26, he was 62. He was dragged out of the vehicle, handcuffed, driven past Boston Medical Center, and taken to a cell D4, where he lay for 5 hours having a stroke. And an ambulance was finally called when he began to vomit and have difficulty breathing. All I can say is, had an ambulance been called, it would have saved my husband amazing amounts of pain and suffering. Most people don't survive a hemorrhagic stroke. By God's grace, he did. I'm a pastor. I'm a believer in the power of God to do amazing things. But he lost his career because he's unable to remember things. He's unable to walk without a cane. And all I can say is, please pass this bill so people like me don't have to come up here and give testimony anymore. I've been here several times. And people like the police don't have the responsibility and the burden of making serious medical decisions in the field. Thank you for hearing me today.
Thank you, Van Copeland. Any questions from the committee? See none. Thank you for sharing your story.
Thank you.
I'll call up Dr. Stephen Wright.
Edwards and Day, thank you very much for the time. My name is Stephen Wright. I'm a retired physician. I used to be chief of medicine at the Brigham Faulkner Hospital System. And I retired in 2017, and since then I've been teaching in Norfolk Prison in the college education program. I'm very familiar with incarcerated people. I became involved with the wonderful committee supporting the Medical Civil Rights Act, looking at custodial deaths and outcomes. And the 2 bills that I'm speaking to today, H 1743 and S 1230, balance each other. One is enforces data gathering. One of the challenges in this field is understanding the magnitude of the problem. I think we all know of the tremendous number of custodial deaths, which are really alarming. And I hate to say it, but the Commonwealth of Massachusetts is in the bottom third of the nation in terms of preventable custodial deaths. That's not an enviable position for us to be in. Just to borrow a little bit on my experience in the hospital, we did a monthly medical morbidity mortality conference. And we discussed a case that had an unfavorable outcome. And at the end of those discussions, I always said, okay, so if a patient comes to our emergency room this afternoon with the same things that we were just talking about with this patient who died, what have we learned? How are we going to do things differently? That's what this is about. We know, or we're getting to understand, get our hands around through the data program, the magnitude of this problem. Now the question is, we've identified it, what are we going to do about it? We can't just say, oh, that's interesting. Connecticut, as you heard, was right out of the first out of the chute, 2023. They introduced this bill. It passed unanimously in the first day of discussion. Other states, New York and Colorado, are actively engaged in this discussion. We have been for some time without a good outcome. I want to stress that this bill is not meant to be punitive. The police are doing a wonderful job in very dangerous circumstances. And understandably, this is not, we're looking for ways to make the systems work better, to activate emergency medical services more promptly. We were invited as a group to give a testimonial at the National Convention of EMS in Pennsylvania last spring. And I described, or we showed a lot of body cams. And it was this one particular one where the person on the ground was restrained, handcuffed, and transported face down. And there were 175 EMS attendants in that room. And they all went, oh, they knew it was wrong. And not surprisingly, when the ambulance got to the destination, the patient had died. So there are certainly fixable things that went on. I think I would just like to underscore the importance of the bill. Why wouldn't we be in favor of a bill that saves lives? It's unconscionable that we would say we don't want to talk about it. This is a very major issue for the country, and for Massachusetts in particular. So I support the bill in the strongest terms possible. Thank you for your time.
Thank you for your testimony. Any questions? This time, seeing none, thank you. Is anyone here who signed up to testify in person that has not been called yet before we move to virtual testimony? Okay, we'll move to Timothy McGrath. Not present. I'll call Vicki Willis.
I'm here.
Welcome.
Thank you.
Go right ahead.
I'm trying to get my emotions under control. I'm here in support of the Medical Civil Rights Act, H 1743, 1745. I'm sure you all know the numbers by now. I'm a mother who's lost her child. My son was 27. He lasted 36 hours. 36 hours is how long my son lasted, and he needed medical help. I'm here to ask you all to please consider victims like my son and others who needed medical assistance. In the state of Massachusetts, between 2021 and 2023, there were 87 lives that were lost inside of the Department of Corrections. The number is closer to 349 people who have lost their lives. Like my son, I can't hold him. I can't touch him. I can't go dancing with him anymore. My life has been in shambles. I came out to your glorious state to ask, and I expressed it. I told you all, I was mad at God for a year because my son is no longer with me. My son was my best friend. I've been trying to contain my emotions, but medical civil rights is not an option. Please consider, you have a mother, a brother, a sister, a child, a daughter. I just want you to picture them right now and look at my face and acknowledge the pain of the impacted families. My son has been gone to God since August of 2022, and I cry every night. I call his name out today, and he cannot answer me. He cannot call me. I cannot fix his dinner. I can't wash his clothes. I'm asking you to think about passing this legislation so you don't have mothers like me, fathers like me, broken-hearted, wondering why our children are dead.
Thank you, Ms. Willis, for your testimony, and on behalf of the committee, incredibly sorry for your loss and the pain that you're still suffering. But thank you for sharing your testimony with us. Are there questions or comments from the committee? Seeing none at this time, thank you again, Ms. Willis, for your testimony. I'll move now to Lane Magwood, virtually.
Yes, thank you. Thank you, Chair Day. Chair Day, Chair Edwards, members of the committee. On July 21st, 2022, my family's life changed forever. My loved one's life was cut short, tragically, preventively, while in local jail. Not prison, not the penitentiary, but temporary custody of the state. Local jail. Listen to me, please. Anyone who is experiencing a medical emergency during contact with law enforcement should have the right to emergency medical care. S-1230, S-1232, H-1743, H-1745, the Act to study the delivery of medical care to persons who are held in custody, the Medical Civil Rights Act. Al Tariq Pleasant, Al Copeland, Kevin Wingo, Walter Jordan, Hayden Shuck, Andrew Kearse, Michael Sadie. These are people, families, communities that will never be the same. The U.S. Department of Justice has already called for federal changes regarding the publishing of this data. These are data related to custodial deaths while in law enforcement custody. Governor Healy already supports the Medical Civil Rights Bill. I leave you with this thought. On February 15th of 2022, the Nero's Law was passed under Governor Baker, which allows the emergency medical care and transport for police canines. Why isn't this already in place for human beings? It's so easy to ignore or minimize until it happens to you, until it is your childhood friend, your neighbor's son, your daughter's schoolmate. It's easy to ignore when it's adjacent and not proximal, but the day will come when it is in your face. Members of the press, Joint Judiciary Committee members, Chairs Edwards and Day, I implore you to move forward with the passing of these two bills. As a soon-to-be advanced practice provider who's already standing on the front lines, I am simply echoing the words of everything that the people who have come before me have said, all in favor with none in opposition, to move forward with these bills. Thank you.
Thank you for your testimony. Ms. Magwood, any questions from the committee at this time? Seeing none, thank you. Move now to Anne Marie Grant of Impacted Families.
Good afternoon, members of the Joint Judiciary Committee. First of all, I want to acknowledge the courage and bravery of my fellow impacted families. They're sharing their pain and hopes you will hear our pleas that have fallen on the deaf ears of elected officials in Massachusetts for far too long. I am testifying in urgent support of H 1743, the Medical Civil Rights Act. I'm testifying again because this body failed to pass the Medical Civil Rights Act in 2023, and each time prior it was presented. And because of that failure, more people have died during medical emergencies, during encounters with law enforcement. Lives are being lost senselessly, and it is because elected officials chose inaction over the preservation of the safety of human lives. Excuse me. My brother Thomas Purdy was a Massachusetts resident on October 4th, 2015, while he was on vacation in Reno, Nevada. He experienced a mental health crisis on a casino floor. They called police. He was nonviolent. He was not a threat. He told officers he could not breathe, that he had had lung surgery, that he needed an ambulance, and that they were going to kill him. Instead of medical attention, he was hogtied for over 40 minutes and asphyxiated to death while he begged for help and medical attention. Had my brother's medical care not been delayed for over 2 hours, he would be alive today. Thomas should be alive today, and so should Mass residents Miguel Estrella, Brendan Riley, Francis Gigliotti, David Woodman, and so many others whose names should never have to be read in this chamber. Every single one of them would still be here if this law had already been in place. I asked, what would you choose if it were your loved one? A delayed ride to a jail cell or an avoidable delayed medical care that ends in their death? This bill is not complicated, it's common sense. If we can pass Nero's law to guarantee medical care for a police dog, then shame on you if you cannot pass a bill to protect human beings. I don't want any more families knowing this heartache due to an avoidable death, due to delayed medical care during an encounter with law enforcement. Please pass the Medical Civil Rights Act. Stop letting community members in the Commonwealth die while it's debated by elected officials whether their lives are worth saving. Elected officials felt the dog's life was worthy of medical care. I ask you, aren't your constituents' lives just as worthy and deserving of a right to emergency medical care during an encounter with law enforcement as a dog? Every minute this bill is delayed, another life is at risk. Ask yourself, will you be remembered for saving lives, or will you be remembered for standing by while people died avoidable deaths? Thank you.
Any testimony, questions from the committee? Seeing none, I'll move on now to Mary Melinda Castellan. Not present. Frederick L. Brown, former Mass Court of Appeals Justice. Judge Brown. Judge Brown? Is that on mute?
He's muted.
Judge Brown, if you're trying to talk, you're on mute. You could unmute yourself. All right, we'll come back. We'll move on to Joshua Lopez. Not present. Angelique Negroni-Kierce. Not present. Dr. Ronald Aki. Not present. Erica Swan.
Present.
Welcome.
Thank you. I'm here to compel the court to pass the bills for H 1743 and H 1745 for the emergency medical care and the medical civil rights. I compel the court to pass this bill. Families are impacted. My dear friend is impacted. I talk to my friend weekly, and I feel her pain because her son was in law enforcement's hands, and he did not get the proper medical care. Me, as a nurse and worked in the corrections field, it's very detrimental that this bill be passed, so there's no more families or friends or acquaintances be affected by the loss of families who lose their lives in custody. Thank you for hearing me.
Thank you, Ms. Swan. Is that, I apologize, is that the end of your testimony?
Yes.
Thank you for sharing it with us. Does the committee have any questions this time? Seeing none, thank you for your patience and your testimony. Appreciate it. Move on now to Sandra Meyer, not present. Cassandra Greer of the Nicholas Lee Foundation, not present. Caitlin Riley.
Hey there, can you hear me?
Welcome. We've got you.
Okay, perfect. 1 second here. Okay, first, I'm testifying obviously for the Medical Civil Rights Act and the Data Reporting Bill. And as many of you probably know at this point, my name is Caitlin Riley Hand, and I am the sister to Brendan Riley, who was killed in Lexington, Massachusetts on February 12th of 2022. To start, I wanted to acknowledge that the first individual man who spoke his testimony, his name is Jeff. He cited data in my op-ed, and I believe he said he quoted it almost directly, that there were over 300 deaths since 2019, and he is in fact correct. Just to clarify, the stats are actually more than over 349 deaths, and those are not federal, those are in the state of Massachusetts. So just to be clear, that data is very precise and has been checked many times. So that is Massachusetts data, and that is from 2019 and all recent data. Further, I will now start my testimony. So for over 2 years, I have advocated for the passage of this bill. For many of those state meetings, I have spoken very little. Today, by the grace of God, I published an op-ed in the Boston Globe. I plan to issue all state offices a copy in hopes that it helps to honestly inform both the police, the public, and the entire Massachusetts government. After years of advocating for this bill and dedicating countless hours to understanding the issues surrounding death, such as my brother's, and everyone who sits before you today and testifies, and so many others who have remained silent, it feels almost cruel that you all have never passed this out of committee. A life-saving bill deemed flawless by multiple appellate justices that would build back trust in our law enforcement, save lives, keep families from living through horrific tragedies, and save taxpayers money. It is a bill that would allocate funding for key training for law enforcement officers across the state, one that they desperately need and want, and frankly, one that they deserve. Yet it feels like there is an effort Yet it feels like there is an effort to make these bills and those who support them to go away, nearly at every juncture. With bills as important as these, which have been met with no overt opposition, what could possibly be the real reason so many lawmakers continue to remain silent? If we again find ourselves with the same questions, the same silence, the same, frankly, excuses around these bills, and we do not advance out of committee, again, I must ask, has anyone considered that this seems very odd? Well, this time I hope someone, possibly an auditor, does. The public and many leaders in this building must understand, do not mistaken that the lack of vocal support for these bills, both today and every day for years, is happening because people do not want to support. The trust in the legislature is broken. The intimidation when you support feels very real, and it is very wrong. It takes true courage to support this bill, and that should not be the case. Committee chairs, with sincere respect, if we continue down this same path and ignore this bill for the wrong reasons all over again this session, someone else will die. They might die tomorrow. They may die next week. There may be 10 this month. This is absolutely atrocious what's occurring. And frankly, it's Massachusetts. This is Massachusetts. It's not federal. That's happening too, but this is a Massachusetts problem. The data is accurate and it's not lying. These lives are now in your hands, and I pray you will finally do the right thing. I would like to thank both Senator Pascal Connor and Representative Christopher Hendricks. You are both heroes, and I hope you are treated as such. Thank you.
Thank you. Any questions or comments from the committee this time? Seeing none, thank you. We will, is Judge Brown back online? No. Okay, we'll move on to testimony and consideration of H 1745 S 1232, specifically an act to study the delivery of medical care to persons held in custody, and call on Andrea Jenkins virtually.
Hello, Chair. My name is Andrea Jenkins, and I'm here to testify in strong support of the Medical Civil Rights Act, and I'm here in support of Altair Pleasant. And I'm sure that this bill will definitely ensure that people that are held in custody receive medical care that they need and that they deserve. Timely medical care is a basic human right. No one should die or suffer because help has been either avoided or delayed. Police are not doctors, and only trained medical professionals should decide if someone needs treatment. Protecting health in custody strengthens community confidence in the justice system. Marginalized communities such as people that are Black and brown are most harmed by denial of care while they're in custody. This bill will ensure fairness for all of those people. I believe that the state of Massachusetts can set the standard that the custody should never mean loss of basic human rights. And I would like to ask you all, what would you do if it was your family that experienced this? Everyone should have the right to medical care in custody. Thank you.
Thank you for your testimony. Any questions from the committee this time? Seeing none, thank you again, Ms. Jenkins. I'll move now to Danetta Scott, virtually.
Thank you for allowing me to testify. I am coming to you on behalf of the Medical Civil Rights Act. Son was an active duty soldier who checked himself in to a county jail to later find himself begging for his life for 2 hours before they decided to get him medical care. This bill is common sense. I have no words to even express how simple it is. I don't understand why it hasn't been passed. If that bill had been in place, my son would still be here. He would be raising his children and serving his country. His life was taken away from him needlessly. And for what? I never imagined that I would be in this situation. I urge you to vote for this bill before it's you standing in my shoes. We don't want that to happen. All of us impacted family members are coming to you and begging you to pass this bill so you never have to suffer the anguish that we have had to suffer. It's a simple decision. Vote yes on the Medical Civil Rights Act. Thank you for your time.
Thank you for your testimony, Ms. Scott. Any questions from the committee at this time? Seeing none, thank you. As a reminder, we've received a few written testimony pieces offered up today, but as a reminder, anyone may submit written testimony by mail to the Joint Committee on the Judiciary. Again, I'll repeat the addresses there: 24 Beacon Street, room 136, Boston, Mass. 02133. By email on House bills, you may email Talia Quinn at talia.quinn@mahouse.gov. For Senate bills, Eduardo Moreno Mendez at eduardo.moreno@masenate.gov with a CC to Christiana Golden at christiana.golden@masenate.gov. All written testimony received by the committee will be made publicly available. And I thank you again for your testimony and your patience, and hope you have a wonderful night. Thank you.
All right. Well, thank you very much for joining, everybody. That was a long one. So yeah, I mean, you listen to the testimony all day. I mean, that was, almost, 4 hours of, testimony, and everybody getting up there and telling their stories. Some of the stuff earlier, I mean, didn't pertain to this act, but it really, it makes you think of what's going on behind these doors day in and day out. I mean, this is just one day. This is a, handful of hours. So it's really important that, people are getting involved and people are seeing what's happening. I mean, I learned a lot today just from listening to everything. I've really been engaged all afternoon. So, so kudos to Peter and to Jen Root for getting up there and speaking. Again, if you missed Peter, I'll repost it. We'll clip it out of the stream here. But Peter was at about the 2-hour, 55-minute mark, and Jen Root was shortly thereafter at the 3-hour and 9-minute mark. So we'll post those. We'll get those clipped out and put them on the Facebook page. Tracy was going to go live, but she's been there all day long too. They're just getting out of there now. So we will be live Thursday night at 6:30. We have Peter Murphy on, and we're going to talk about today's events, and we're going to talk about a whole bunch of other things. So hopefully we'll see you guys then. And thanks again for watching. And we'll catch up with you soon. Brandy, we'll talk to you soon as well. Dennis, everybody that was in the chat today, thank you all. And we'll catch up. Thank you, Abby. We'll catch up to you. Hopefully we'll see you guys all on Thursday, if not sooner. Have a good night. Bye.
Sing